Welcome everyone to the 11th meeting of the House Common Standing Committee on Justice and Human Rights. Pursuant to the order of reference on October 1, the committee's meeting to continue its study of Bill C-9, an act to amend the criminal code on hate propaganda, hate crime, and access to religious or cultural practices. I will skip over most of the introductory instructions. With us from the Edmonton Police Service, Nicole Chapdelaine, Deputy Chief, welcome. From the Christian Legal Fellowship, Derek Ross, Executive Director, and from the International Civil Liberties Monitoring Group, Timothy McSorley, the National Coordinator. We do have one witness that had a last-minute challenge, so couldn't make it. And so fortunately or unfortunately, we have three witnesses for this first panel, so we'll be able to ask them questions, and we'll probably go through, at least get to the third round if we have time, given that we are splitting this in 2 hours and a half. I remind the witnesses that they have 5 minutes for their opening statements, followed by questions from members of the committee, and I'll read out the roll call when the three witnesses have finished giving their opening statements. So I'll start with the Edmonton Police Force. Nicole, welcome. You have 5 minutes. If that goes over, I will remind you, and I'll afford you a few seconds to conclude if you do go over, but please do try to keep it to 5 minutes. Thank you. The floor is yours.
Good. Thank you. Good afternoon, Chair and members of the Standing Committee on Justice and Human Rights. Thank you for the opportunity to speak today on the critical issue of hate crimes and provide insights from a law enforcement perspective on Bill C-9, the Combating Hate Act. As Deputy Chief of the Edmonton Police Service, I oversee the Investigations and Support Services Bureau, which includes Major Investigations, Hate Crime Unit, and Protest Liaison Unit. Hate crimes require appropriate deterrence and public denunciation given the fear and harm the hate crime offender seeks to instill in our community. C-9's proposed framework incorporates key legal principles for police in a balanced democracy, recognizing offender rehabilitation, denunciation, and deterrence alongside expanded abilities for police to keep our community safe. Edmonton is a fast-growing, welcoming, and diverse city. To keep all citizens safe and secure, our service supports all Bill C-9's recommendations. I will now review my support for C-9's proposed amendments. Removal of AG consent for hate propaganda offenses is an important change supported by our service. Police agencies can investigate these crimes while working with the Crown prosecutors. Police are required to weigh and balance information separated from evidence and objectively review suspicion of hate crimes from lawful, reasonable grounds to lay charges. The Crown's crucial role put into place decades ago to review all police charges at the higher reasonable likelihood of conviction standards will continue to apply, even with removal of AG consent. Consistent with all criminal code offenses, the EPS continues to support this additional level of prosecutorial oversight, so police and the Crown remain apolitical from any decision to lay or prosecute charges. However, from a police perspective, I also recognize that I speak on behalf of a police agency that has a specialized hate crime unit to conduct hate propaganda criminal investigations. EPS also supports the additional offense of willful promotion of hatred against an identifiable group by displaying certain symbols, specifically like the swastika, the SS bolt, or symbols of listed terrorist entities. This section clarifies these type of symbols, but also reiterates the requirement that police establish that a suspect was willfully promoting hatred against an identifiable group in public. EPS supports the creation of offenses of intimidation to provoke fear or obstruction of a person accessing certain places that are primarily used for religious worship or by an identifiable group for certain purposes. Again, this clarifies police arrest or detention powers. EPS strongly supports the implementation of a standalone hate crime offense. The current lack of an offense impacts investigations, hate crime data collection, and community safety operations. The following brief highlights our position. First, a standalone section would establish a consistent national definition of hate crime. Across Canada, more than 170 police agencies operate with varied definitions or none at all, creating inconsistency, confusion, and gaps in accountability. A single codified definition would align law enforcement, justice partners, the Crown, and academic research, enabling a coordinated and effective national response. Second, it would allow accurate and reliable data collection to help reduce hate crimes nationwide. Police often record hate crimes under general offenses like assault or mischief, making them difficult to track. A dedicated section would permit Statistics Canada to better capture offenses, improving federal and provincial data for police-driven public security. Third, standardized reporting would help identify repeat offenders, extremist networks, and emerging hate threats, allowing police to proactively reduce crime with appropriately allocated police resources. Fourth, reliable data supports evidence-based policing and fair allocation of funding. Governments cannot fund criminal issues that are not objectively measured. Better data informs government policy, Crown prosecution, investigations, prevention programs, victim support, and community initiatives. Fifth, establishing the section increases public trust. Codifying hate crime as a distinct offense sends a clear message. Hate crimes against marginalized groups will never be tolerated in Canada. Sixth, this codification reaffirms Canada's democratic values of equality, inclusion, and respect for diversity and human rights. Hate crimes target individuals and the very principles that sustain Canada's social cohesion. Finally, this change will enhance police and Crown education and provide clarity to the courts. A clear legislative framework ensures consistent and informed justice across all provinces and territories. Canada's hate crime laws have been historically reactive. C9's changes would mark the difference of proactive and preventative steps forward for everyone involved in the criminal justice. In closing, EPS supports the objectives of Bill C9, strengthening our legislative framework, improving data integrity and intelligence sharing, enhancing hate crime prevention, and rebuilding public trust benefits for everyone. Thank you.
Thank you, Deputy Chief. Over to you, Derek. The floor is yours.
Thank you, Mr. Chair. Good afternoon. It is a privilege to appear today on behalf of Christian Legal Fellowship. Thank you for the opportunity to share our perspectives on Bill C9. CLF is a national association of over 750 legal professionals working with faith communities and other groups across Canada. CLF is also an NGO with special consultative status with the United Nations and has intervened as a friend of the court in over 40 cases involving the Canadian Charter of Rights and Freedoms, including in Whatcott, where the Supreme Court cited CLF submissions in its unanimous decision. Let me start by affirming that CLF shares the government's desire to combat all acts that propagate and normalize hatred. And so we wish to ensure that initiatives like Bill C9 are both effective and constitutionally sound. And that requires a carefully tailored approach in defining exactly what is being criminalized and in what circumstances. The criminal code is, as you know, contains the most severe penalties in our legal system. So the stakes are high in finding the right balance. It means the difference between someone's liberty or incarceration. So in this context, when it comes to defining hateful expression, we need to ask some hard questions. When should someone be imprisoned, separated from their families, from society, branded a criminal because of the words they speak or the views they express? What might we deprive our communities of? Whose voices might be silenced if we don't strike the right balance? What legitimate ideas might never be heard if people are afraid to speak up for fear of being prosecuted as hateful when they aren't hateful at all? At the same time, how do we deal with the concerns that we've just heard about with the growing animus in our country, particularly that which is directed towards minority religious groups? How do we deal with the very real harms that flow from that animus? These are important questions that this committee is wrestling with, that this bill is wrestling with, that we all are wrestling with. And it's important, it's absolutely crucial that we get this right. It is often said that the law is a teacher, and people will learn and look to laws like this one, especially when it comes to our public discourse. In fact, the Supreme Court recently recognized that allegations of hatred are often used in public discourse and used in ways that well exceed their narrow meaning within the legal system. So when it comes to the criminal law, we have to have a clear understanding of what we mean by hatred and why it is a legitimate subject for criminal intervention. Hatred of people is evil, and public manifestations of that evil are appropriately addressed through the criminal law. Other aspects of hatred ought to be addressed through different avenues, such as educational, mental, spiritual, and community supports. Criminal intervention is justified only when someone takes action, what the Supreme Court has called extreme manifestations of hatred. And it is important that we always recognize why that is. It's not because we find certain views offensive, as repugnant as we might find them. It's not because we object to what people think or feel. It's the mode and effect of expression, not the expression itself or the content of the expression itself, that the law must target. The Supreme Court has been very clear on that point. And so the criminal law is concerned when someone takes action to mobilize others to deny a group's intrinsic dignity, to treat them as lesser beings, to take actions which effectively dehumanize others, actions which are ultimately a rejection of a basic compact of our community life together. That is what should be targeted. Expressions that fall short of that threshold, offensive as they might be, should not be criminalized. And so while there's a legitimate role for the criminal law in combating hatred, the law must be carefully tailored to those goals. And we've identified three primary concerns with Bill C-9 in this regard. I'll just quickly summarize them in conclusion. First is the definition of hatred. The term hatred in any context is highly susceptible to subjective interpretation and must be defined more precisely than it is currently in the bill. Second, the proposed new motive offense requires clarification for a number of reasons, which we can get into. We suggest in our written brief that this offense should focus not on an accused's internal emotional motivations, but on whether an accused commits an offense with the intent to incite hatred. And again, how we define hatred is a crucial issue here. And finally, there should be explicit recognition of the freedom to discuss and criticize beliefs, opinions, or practices in good faith. And this clearly would communicate that disagreement is not detestation. That is also consistent with the defenses contained in Section 319.3, which should be also retained to help ensure that the legislation complies with the Charter. A clear line must be drawn between expression that seeks to vilify groups on the one hand and expression which simply seeks to challenge ideas on the other. And substantive amendments are needed in Bill C-9 to help achieve that demarcation and strengthen the government's efforts to combat hatred in line with the Charter. Thank you very much.
Thank you, Mr. Ross. Over to you, Tim, for 5 minutes.
Thank you very much, Mr. Chair, and thank you to the committee for this invitation today. I'm here on behalf of the International Civil Liberties Monitoring Group, a coalition of 45 Canadian organizations from a broad range of sectors. ICLMG was founded in 2002 to serve as a watchdog around the impacts of Canada's national security and anti-terrorism laws on civil liberties. Our coalition has observed with distress the increase in hate-based violence across Canada over the past several years. We believe that greater measures must be taken to address instances of hate-based violence, but that such measures must be targeted and specific and ensure that they do not unduly impact the civil liberties or charter rights of Canadians, including of those who the measures are ostensibly meant to protect. Unfortunately, several measures in C-9 fail that test. We share the concerns of the 37 other signatories of an open letter led by the Canadian Civil Liberties Association that pointed to detailed and substantial problems with Bill C-9 and ultimately called for it to be withdrawn and revisited. While we share the overall concerns expressed by our colleagues, today I would like to focus on one particular area of the bill. We are concerned with the provisions in Clause 4 of the bill that would create a new offense of willfully promoting hatred against any identifiable group by displaying certain symbols in public. These new provisions pose a significant threat to freedom of expression by granting broad and discretionary powers to police and by basing the determination of which symbols are included on a flawed terrorist listing process. Moreover, the provisions are redundant and therefore unnecessary. To begin with that last point, the willful promotion of hatred is already a criminal code offense. It is understood that the determination of willfully promoting hatred can already include the use of particular symbols, including those of listed terrorist entities. The only difference would be the wording will place greater emphasis on the use of a symbol in the commission of a hate offense. This leads to our second concern, that the wording of this new offense creates the serious risk of police making discretionary decisions related to what constitutes a symbol, quote, associated with, or, quote, used by a listed terrorist entity. Over the past several months, we have seen heated arguments and accusations that certain symbols associated with protests in support of Palestinian human rights are either hateful, are associated with a terrorist entity, or both. Peaceful and lawful protests have been unjustly accused of fomenting hatred based on the signs and slogans that they carry or chant. Under this new legislation, police can make a determination in the middle of a march or protest, not just of what constitutes a symbol associated with a terrorist entity, but that is being used to willfully promote hatred. There will continue to be pressure on police to stop and arrest anybody carrying a symbol that they may believe is used by or associated with a terrorist entity, whether that be a Hamas or Hezbollah flag, a kafia, or a disputed slogan on a sign. This is made more complicated by the fact that police would be empowered to make the decision that a symbol so nearly resembles the symbol associated with a terrorist entity. For example, would Arabic writing on a sign that a police officer believes is similar enough to writing found on imagery used by a illicit terrorist entity give rise to the grounds to arrest the individual? And this confusion would, of course, apply to all listed entities and could impact protests from a broad range of communities. These issues raise important questions of guilt by association or the tarring of entire movements with suspicion. We have seen this throughout the last 20 years of anti-terrorism measures, and acutely over the last 2 years during protests or rallies, in academic settings, or even in parliamentary committees meetings. Given the severe potential for overreach, along with the stigma of being accused of committing a hate crime, we believe that this law will create a significant chill on free expression and dissent. Finally, we are also troubled by the fact that the symbols in question are based on the terrorist entities list, which itself is a problematic tool. Serious issues with Canada's terrorist entities listing procedure include the imposition of serious financial and possibly criminal consequences on the basis of unaccountable, secret executive listing decisions, the use of secret evidence, and the absence of adequate avenues for challenging listings and obtaining redress. Decisions to list or not list can also be political in nature. New criminal offenses, especially those that themselves invite discretionary decision-making, should not be founded on a process already demonstrated to raise significant constitutional concerns. As mentioned above, this is simply one of the many areas of concern with Bill C-9. Beyond removing this section, we agree that the bill should be withdrawn and the government's approach revisited. Thank you very much, and I look forward to the questions.
Thank you, Mr. McSorley. Members, we have a good chunk of time. I'll read out the names for the first round. MP Lawton, MP Chang et Monsieur Fortin. 6 minutes chaque, en suivi dans la séquence de 5-5, 2,5, 5-5.
6 minutes each, and then 5-5-5. I'll start on this side with 6 minutes.
You could switch over if you want to. Okay, so switch over with MP Brock. Yeah.
Thank you, Chair, and thank you to all the witnesses for your attendance virtually and your participation in this important study. With time permitting, I'd like to ask questions for all three. I will start with Deputy Chief Chapdelaine. Thank you for your appearance. I've had the privilege of attending your city a number of times over the spring and summer, and met with, I believe, the acting chief at the time, and also the president of the Edmonton Police Association, predominantly to talk about bail issues and sentencing issues. We never really got into protests and hateful demonstrations that have plagued this country over the last several years. So I'd like to know, because when I do my tours across the country, I get a lot of mixed reviews from community members and stakeholders about the differences displayed by police services in relation to how they deal with these type of protests. And I'm not going to mention the jurisdiction, but I've actually had a couple of jurisdictions where they basically said they take their marching orders from the local municipality. And if the local municipality has a political persuasion to allow these types of events to occur, they've been instructed to act not necessarily as sworn-in police officers, but more or less just peacekeepers. And I've had numerous examples brought to my attention of open acts of criminality, and the police simply are not charging. So I'd like to know from your perspective what is happening on the ground in Edmonton.
Thank you for the question. So in regards to that, like we have built up in Edmonton a large, a contingent of members who work specifically with multiple communities around these kind of events. Obviously, our direction to our membership is not driven so much by the municipality, but by ourselves as executives in here and what our expectations are about treating all people equally, right? Protecting the grounds that people have for freedom of speech, but ensuring that it's done in a manner that is respectful of others. And so I know, with EPS, and I mentioned it in some of the other stuff, with our ability to have a very active hate crimes unit as compared to many other police of jurisdiction, we work closely together with our hate crimes unit, with our police liaison team who work with some of the protests as these things come up, and have built strong relationships with community to understand when these things are going to happen or people want to have events, particularly in Edmonton. We have it at our provincial legislative grounds. We work closely with them to ensure that it's done in a safe manner. Of course, we try and lay out those expectations and develop what this is going to look like prior to these events. So a lot of it comes down to some good planning and making sure that people are abiding by it. And if there is a need to do any further enforcement, right, we work through that. We don't necessarily will act immediately upon, then we'll continue to take that and investigate if there's a need afterwards.
Thank you, Chief. I have limited time, so unfortunately I have to cut you off there. Is it fair to say that those who have crossed the line of criminality with respect to these demonstrations, your service has made arrests where warranted?
I would say so. We haven't done very many arrests in that regard, but where there have been some, we have looked at what they've been doing. Now, what the charges were laid may have been, like I said, the mischief. It might not have been totally in regards to the hate crimes.
Do you have the view?
Yes.
Do you have the view that there are existing laws in place under the criminal code to deal with these issues surrounding protests and the hate that is demonstrated at the protests, that the tools already exist and is not necessarily required that Bill C-9 provide additional police powers? Are you of that view, yes or no?
I'd say yes and no. I think there are laws that exist right now that we utilize because that's what we have to lean on. I think some of the changes in Bill C-9 provide the ability for us to lay the appropriate charges and capture that exactly about what exactly we're seeing and dealing with. And that's part of the problem of being able to not communicate what this looks like, is because we don't have specific charge types that capture this appropriately.
You said in your opening statement that you're supportive of the removal of AG consent. I wholeheartedly, with respect, disagree with you. As a former Crown attorney, I did not think the process to be overly cumbersome, and it provided the necessary overview mechanism when dealing with laying of these unique charges that we often do not see on a regular basis. But there is a problem with Bill C-9, and it's eliminated the oversight, the Crown oversight with respect to private prosecutions. Do you appreciate the error and the problem that exists?
Well, I just think right now, because there is so much gray in this space, that's why there's a need when we're exploring these kind of charges that we need to have that conversation. I think with some more specificity around what these charges are, I think that the things that are in place right now to allow for the Crown prosecutors to work with police to make sure we reach the level that's required can happen and can occur.
Okay. With time permitting, I'm going to turn matters over to Mr. Is that my time? I don't have time. I'm sorry to the rest of the panelists.
I made a mistake and read out the second hour, so that's on me. We'll follow with MP Dillon, ensuite Monsieur Fortin, et pour le deuxième tour, j'annoncerai le cas échéant les...
For the next round, I'll announce whatever members.
Yeah. MP Dillon for 6 minutes.
So much, Mr. Chair, and my first questions are for Deputy Chapdelaine. Thank you so much for your testimony today and relaying the importance as a frontline officer of incidents that are occurring in the community, and to also share your practical experience and knowledge with us as well, which is very important because we keep hearing over and over words are just words, hateful words are just words. Can you please tell us a little bit about the impact of these words in the community? And do you believe that they embolden and give those who are inciting violence to those who are capable of physical violence the ability and the license to go ahead and commit hateful crimes?
Yeah, thank you for the question. I think right now, to answer your first part about that, like the impacted community obviously is, it's quite heavy on some of the communities that see this and face this. I mean, we have difficulty as a police agency when we get into these spaces and try and, for lack of a better term, mediate some of the things that are happening, things that are being said, and we also respect that. Quite often, people have their opinion, and not to use the catchphrase used, it's awful, but it's lawful. So, we're quite attuned to the fact that when these things happen, the impact that it has, and working with those communities to support and have them understand that, our role as police officers and police agencies is to protect that freedom of speech, but make sure it's done in a way that is as respectful as it can be. And sometimes we can't reach the threshold that we need. We feel that this bill provides us with some of that more, like I said, more specificity around what these acts, what hate crimes definition is, and allows us to have a bit more ability to, on both sides of the sides here, to talk about what's acceptable and what is not. And right now, I think the gray space causes problems for law enforcement because depending on who is faced with it, they're coming up with their own interpretation of it. Now, we may not go fully to prosecution, but it also does cause harm to people on both sides when we have to interact with them and have those conversations. So it's very impactful. I think we see it, and I think people are seeking some clarity around this so that as law enforcement agencies, we can deal with it as best as we can when asked to do the jobs that we are asked to do and that we've signed up to do.
Thank you so much, and it's going to help me get right into the next question, which law enforcement keeps getting asked about. Removing the Attorney General consent requirement to help police act more swiftly. How important is it for frontline officers such as yourself or your team to be able to proceed quickly when dealing with hate-motivated offenses?
Well, I think the quicker, so thank you for that question as well. I think the quicker we can move through these things, the less time it takes for us to sort of sit there and wonder what's happening. So, I mean, obviously, again, it's going to be as quick as it is working with our Crown prosecutor partners around what this looks like before we lay these charges. When you add layers of approvals, it slows things down. There have been times when we've laid some charges and it's taken up to 18 months, and the impact that continues to have on community and those who are affected by this, regardless of what the outcome of the AG decision is on it, is like quite impactful for both sides, right? So the quicker we can make the appropriate decisions, and I think there are checks and balances along the way in an investigation and consultation with prosecutors to ensure the evidence exists for these charges. And so, although the AG consent has been in place since its introduction to the criminal code in the 60s, there's been an increase in accountability and improved procedures since that time. And so, currently proceeding with charges rest solely on the decision right now with the AG. Removing that allows us to move that a bit more quickly, and I think has less impact on those involved.
You've actually answered two of my next questions. So it does show victims that hate incidents are taken seriously and dealt with immediately. And you keep speaking about interacting with them. I guess you see a lot of psychological harm as well. I mean, just because it's not physical doesn't mean psychological harm is absent from this whole scenario. Am I correct?
Correct. And we've actually seen a shift in the last year and a bit from more psychological harm, and that is always going to exist, but you're moving from the psychological with the addition of physical harm that we're seeing an increase, specifically in Edmonton in 2024 and 2025 that we've noted. So I think the psychological will always exist because that exists whether or not you were, there was violence involved in it, but now we're seeing a bit more, we're seeing more violence occurring in the events that we're investigating.
And I want to thank you so much as well for citing during your testimony something beautiful. I tried to capture the words. Hate crimes against marginalized groups will never be tolerated in Canada. I thank you. I thank your force for looking at that in this way. It's very meaningful, very impactful. You said something about the definition of hate crimes being absolutely necessary because it standardizes reporting and helps the police to proactively prevent such crimes because they're not subject to confusion among different police forces. There will be one definition across Canada. Can you please elaborate on that? Thank you.
Yeah, absolutely. And again, like I said, when we speak about the more than 170 police agencies right now that operate with different factions of hate crimes units, right? We don't have all the same sort of resources and funding available in each small agency. And so, you know, in Edmonton, we know we have a strong hate crimes unit, but we also know that sitting across Canada, sitting in meetings that I sit at, my team sit at, when it comes to these discussions, that we see lots of variability around how people treat these and how people interact with people, and why not having a defined definition that actually grounds us about what this is, I think leads to more of the issues that I've seen from my peers presenting here today in regards to that impact on both sides, whether it's the person who's speaking out or the person who's receiving what's being said. And so I think if you have a definition that grounds us across Canada around what this means, it is only going to serve everybody involved much better.
Thank you, Deputy Chief. Monsieur le Député Fortin, 6 minutes.
Merci, Monsieur le Président. Merci.
Thank you, Mr. Chairman. I thank all the witnesses who've joined us today. My first question will be for Mr. Ross. Mr. Ross, I understand you represent the Christian Legal Fellowship, and I want to talk to you about a provision of the Criminal Code, Section 319, which prohibits hate speech against an identifiable group or fomenting hate. These provisions exist to prevent actions to incite hatred or hateful action. But the exception there says that no one can be found guilty of an offense under paragraph 1 or 2 in the following cases. And under B, it says, has expressed an opinion in good faith on a religious topic or an opinion based on a religious text in which the person believes or tries to establish that he agrees. So in your opinion, Mr. Ross, would this defense have its place in the criminal code, or shouldn't we take advantage of this opportunity to eradicate hate, to take those exceptions out of the criminal code? So, Mr. Ross?
Thank you very much for the thoughtful question, Mr. Fortin, and I appreciate the opportunity to engage with you on this because it is a really important issue. The defense that you reference in subsection 3B of 319 has been really important in the court's consideration of the entire anti-hatred framework in section 319. And in fact, this defense and the other defenses in subsection 3 have been pivotal in demonstrating to the courts that the legislation does strike the right balance, that it doesn't intrude too far on citizens' rights to freedom of opinion and expression. And so if this defense or the other defenses for truth, for example, were removed, we would be concerned that that could undermine the constitutionality of this regime and the careful balance that has been struck. Now, the concern, of course, which I understand and am sympathetic to, is that someone might misuse this defense and might try to hide behind religious veneer and use it as a smokescreen to promote hate. And that would not be a good faith defense. That would actually be a misuse of both the defense and, frankly, a misuse of religion. And thankfully, that defense has been interpreted very carefully by the courts to preclude exactly that scenario. The courts have been very clear that this defense cannot be used to cloak hateful expression with impunity. The language they use is as a Trojan horse to carry an intended message of hate. And there hasn't been a single case where the defense has been.
Je m'excuse.
I'm sorry to interrupt you. I don't want to be impolite, but our time is limited, as you know. I'd like to quote a speech we heard in Montreal last year. Adil Shakawi said publicly, and I quote, Allah, take care of these Zionist aggressors, the enemies of the people of Gaza, exterminate them, unquote. Do not spare any of them, unquote. This speech, this quote, was submitted to the Crown Attorney in Quebec, who decided not to charge Mr. Shakawi. many of us were surprised by the absence of charges. Don't you think that an exception like we have in Section 319 could have encouraged the Crown prosecutor to decide there was no way to prosecute Mr. Sheka?
Well, thank you for the question. And I don't want to comment on a specific prosecutorial decision that was made without knowing the full context. But here's what I would say. The courts have been very clear that one cannot simply embed a hateful message in a so-called prayer and expect to receive the benefit of the defense. The courts have specifically said that is not permitted. And so the good faith requirement has been strictly
Je comprends,
enforced.
Monsieur Ross, vous l'avez déjà mentionné.
I understand that, Mr. Ross. The question of good faith is important. It's in the clause. How unfortunately, good faith can be interpreted narrowly or broadly. My question is, should such a legislative provision, doesn't that encourage Crown prosecutors not to prosecute? Here, the individual was calling upon his audience to exterminate the enemies of the people of Gaza. We know that we're talking about Israelis here. I understand that you feel that the question of good faith preserves us from this. Now, I'd like to hear you. I have about 1 minute left. Ms. Chapdelaine, I'd like to hear you on this. What do you think about this?
Ms. Chapdelaine.
Yeah, thank you for the question. And again, not similar to my friend there. I'm not going to, something that I haven't seen or have details on. But I mean, it would have grave concern for me about those comments. And my expectation as somebody on the outside in law enforcement looking at that would have anticipated that would have been prosecuted just based on the language that was used. Obviously, we would invest without the information towards that, but I would have concern with that. And I think you could read into that in regards to what is the intention of what is being said there.
Merci.
I'll just use the chair's prerogative for 2 seconds to ask a follow-up question to Mr. Ross. And as despicable and as unlawful, I believe the statements made by Mr. Shekawi were and would be if they were stated again. We don't know why the prosecution chose not to continue with the charges. And perhaps it is to Mr. Fortin's point. I just want to dig in a bit about the concept of good faith, Mr. Ross. In Leviticus, Deuteronomy, Romans, there's other passages, there is clear hatred towards, for example, homosexuals. I don't understand how the concept of good faith could be invoked if someone were literally invoking a passage from, in this case, the Bible, but there are other religious texts that say the same thing, and somehow say that this is good faith. I mean, clearly there are situations in these texts where these statements are hateful. They should not be used to invoke or be a defense, and there should perhaps be discretion for prosecutors to press charges. I just want to understand what your notion of good faith is in this context, where there are clearly passages in religious texts that are clearly hateful.
So I don't know that I would agree with that characterization, Mr. Chair, that passages are categorically hateful, especially not passages in the Bible. And I think if members of Parliament are of the view that passages of the Bible are hateful, that's something that Canadians should be aware of. And I don't know if that's necessarily what you were communicating there. I think your concern is the way that the Bible might be relied upon or cited to advance particular messages. And that was specifically dealt with in Whatcott. And there the court drew a very careful line between speech that we might view as repugnant or offensive or hurtful versus speech that crosses the line into inciting hatred and promoting hatred and exposing a group to hatred, where there's a very different analysis that needs to be employed there. But just to answer that thoughtful question, the good faith, what is the good faith doing? What it does is ensure that Canadians can engage in religious dialogue or debate or discussion on very difficult, controversial issues that many Canadians are wrestling with truth. And so we have a defense in subsection in subsection 3A, where there's a defense for truth. But that doesn't necessarily apply when we're talking about religious truth, because it would be inappropriate for the courts or for the government to opine categorically on whether a particular religious claim is truthful or not. The courts can't decide, for example, whether Jesus Christ objectively is the Son of God. So what this does is say, when it comes to some of these fundamental questions, we want to preserve room for people to engage in dialogue, both critical of religious texts and relying on religious texts. So it works both ways to try to seek and discern truth without fear of being labeled a blasphemer or a criminal or a hate mongerer by those who find their beliefs offensive and would try to silence them. So I hope that answers your question, Mr. Chair.
Yeah, thank you. I would have lots of follow-ups, but I don't want to take away other members' times. I'll jump to the second round. Thank you for your answer.
Second round of the Liberal member, I guess.
This is chair's discretion. You get it once in a while. I've been sitting here patiently for 10 rounds listening to you guys ask the same questions over and over, so I get one once in a while. You could give it. Well, it goes to MP Brock in that case, so you'll have to fight it out with him. So, Mr. Lawton, over to you for 5 minutes, then Mr. Housefather for 5. Réal, encore une fois, 2 minutes et demie. Mr. Bailey for 5 minutes, and Ms. Latanzio on this round for 5 minutes. Over to you.
Thank you to all the witnesses for taking the time to join us today. I'd like to start with you, Mr. Ross. You were asked by my colleague from the Bloc Québécois, Monsieur Fortin, and also by our chair, Mr. Miller, about the religious defense, to use that term, embedded in Section 319 of the Criminal Code. And just to confirm, you are against any removal of this defense from the hate provisions of the Criminal Code, correct?
Yes, that's correct, precisely because they've been important in upholding the regime as constitutional.
We have seen in a number of debates in society, sometimes public opinion shift. We've seen what is at one point in time held by society change, sometimes in 5 years, in 10 years, in 50 years. We need to be able to have discussions on contentious issues to do that. One example that has come up in this committee's hearing last week on this was the way that we're discussing gender right now and sexual identity. And one of our previous witnesses said that they could actually see a case in which C9, with the lower threshold for what constitutes hate, could lead to criminal charges against someone for going against whatever the liberal orthodoxy is on gender. Would you agree with that concern?
Well, I think that is a concern whether it's on that particular issue or on any number of social issues where Canadians hold very sincere, strongly held views. If we define hatred too imprecisely, then it does create the risk that it could be used or employed to capture not just the speech or the modes of expression that the Supreme Court has been concerned with, but specific ideas that we might find repugnant or offensive, and used to apply hatred in a colloquial sense as opposed to in a criminal sense to speech that is part of what it means to be in a democratic society, to be opposed to to be exposed to opposing views.
There have been, since 2021, at least 123 churches in Canada that have been either burned or vandalized. This has been something that the former Prime Minister, Justin Trudeau, said was, quote, fully understandable. His principal secretary, Gerald Butts, said it was understandable. That's a direct quote. What's your view on the way that we view hate in this country somewhat selectively?
Yeah, thank you for your question. I think it's really important that when we talk about this legislation, that we want to ensure that the criminal code works to protect all communities, all religious communities in Canada. And that's what the Charter requires, is that every group, every faith group is entitled to the full and equal protection of the law. And so it shouldn't, and we don't want to make this about my group versus your group. It's about ensuring that every group has the same protection. And so thank you, Mr. Lawton, for raising attention about some of the very profound concerns that we and many others have about the number of churches that have been burned to the ground in Canada. We are equally concerned about attacks and vandalism directed at synagogues and mosques. This is an issue that we all recognize is a problem in our country. That's why we're here. And so this isn't something that we want to ignore. The question is, what's the best way to address it? And that's what we speak to in our written brief.
Thank you, Mr. Ross. Mr. McSorley, you alluded to flaws that you see in the terror listing process. I just want to understand where you're coming from on this a little bit more clearly. Do you view what happened on October 7th as a terrorist attack?
It was committed by a listed terrorist organization, and we denounced very vocally any attack on civilians and have spoken out that there should be an immediate ceasefire.
Do you personally view it as a terrorist attack?
I believe it as an attack on civilians that can't be justified, and that should be, viewed as being a grave concern. But that we've also seen retaliation that's been outmeasured to the violence on that particular day.
The moral equivalence between Hamas and Israel is interesting in your answer. Do you personally believe Hamas belongs on the terror list in Canada?
I don't have a personal opinion about which organization should be on the terrorist listing. Our position as a coalition, and that's who I'm here to speak on behalf of today, is that the terrorist entities listing is a
Will you
flawed
denounce
process.
Hamas right now as a terrorist organization, yes or no?
It's listed as a terrorist organization, and that's what I'm here to speak on behalf of my organization and our coalition. I'm not here to speak on behalf and say yes or no if the government is wrong for its determination, but rather that the listing itself is a problematic process.
Thank you, Mr. McSorley. Over to you, Mr. Housefather, for 5 minutes.
Thank you very much, Mr. Chair. Deputy Chief, I wanted to ask you a couple questions. Can I start with, would you agree with me if I characterize that this law adds new offenses that give you additional tools in the toolbox? It also clarifies certain existing provisions of the criminal code that will assist you and your officers in clarifying when to charge somebody. And thirdly, it also gives you direction in the sense that it is telling you that the government views these hate-related offenses as very important.
Absolutely, yes, on all three, yeah.
And can I come to the intimidation and obstruction offenses that are added? Do you agree that these new intimidation and obstruction offenses will be helpful to you and your officers in understanding the prioritization of charging people that are blocking access to places of worship, community centers, et cetera?
I think it provides more guidelines for our members. So when they are responding, I think it gives them a more understanding of what they're dealing with and more opportunity for them to make some decisions. Right now, I think it's left to an individual to come up with what they think they're dealing with and try and mitigate things, which at times takes too long because they don't understand and they don't know where to go with it. And so things continue to carry. We could deal with things in a much quicker manner if we have a better idea of what we're trying to deal with.
And one of the things that's, I just wanted to ask the question because it comes up frequently. There are people trying to argue that since the existing criminal code provides for multiple different offenses, the argument has been that police aren't charging under those offenses. As a result, this new law isn't needed. Would you disagree with that claim?
I would disagree with that. I think there's nothing wrong with parliamentarians disaggregating sections for clarification of crimes. We do it already. We do it with assaults, sexual assaults, frauds, false it's there right now, and so it exists, and so this is no different.
And you'd also agree, counter to what has been claimed by a couple of people, that the federal government has no ability to direct the Edmonton Police Services as to what to charge or not charge or tell your officers what to do or not do, correct?
Correct. I mean, at the end of the day, we abide by the criminal code, right? But we still have discretion and we still need to make decisions based on the totality of every event that we respond to. And so it's not as simplistic as that. We have lots of checks and balances and we have relationships with our Crown prosecutors in these spaces in order to make sure that we're making the right determination about how we proceed.
It will also be, for example, like in Montreal, there's a Public Safety Commission of the Agglomeration of Montreal that is the regional government that runs police. That would be the entity, the municipal authority that could give you general guidance as to what intentions it has related to policing, correct?
Correct. We have a police commission that works with us. Doesn't necessarily get involved with the operations, but there's an oversight with us as well as lots of provincial oversight when it comes to police conduct.
Thank you so much. Your clarity has been really appreciated. Mr. Ross, can I ask you a couple of questions? I appreciated the way you approached the bill in terms of offering amendments and general guidance as opposed to saying the bill isn't a good idea at all. I don't think that is what you believe. Do you support the new intimidation and obstruction offenses? And for example, I had in my own riding in March or April of last year a situation where demonstrators surrounded our Jewish community campus, where the offices of the Federation are, and the Holocaust Museum, and the Jewish Public Library, and didn't let people enter or leave the building standing on private and public property for hours. You would agree that that is a problem, right? And that these new intimidation and obstruction offenses will assist to tell police that they should be charging in events like that?
Certainly agree that those and many other examples are hugely problematic. And so you're absolutely right that we do not categorically oppose the bill. We support the intentions and motivations and objectives of the legislation. Like I said, our goal is to see this bill effective and constitutionally sound. When it comes to the specific interference and obstruction offenses, we do have some concerns about their potential breadth, and we would share some of the concerns that have been raised by other groups, the Canadian Civil Liberties Association, just about what constitutes interference and the way that it might capture conduct that it doesn't even necessarily intend to capture. But we'd also point to a number of other provisions that already exist and that should be utilized to address precisely the situations that you've described. And so, and I know this is a question that's been raised elsewhere, there are existing mechanisms. And so whether it's through the new bill or through existing mechanisms.
I'm sorry, I have limited time. I don't mean to interrupt.
Time's up.
My time's up?
Yeah.
Oh, okay. Thank you, Mr. Chair.
Monsieur Fortin, 2 minutes et demie.
Merci.
Mr. Fortin, 2.5 minutes. Thank you, Mr. Chairman. Mr. Ross, in 2.5 minutes, if you'll allow me, I'd like to start the same series of questions for discussion purposes. Let's say I convert to another religion than my own, and that my religion has a Bible, a Torah, whatever the title. There's a religious text that says that another group of individuals, Montrealers, let's say, or Christians, are a demonic creature. They have to be exterminated. Let's say that's a religious text that says that. I convert for all kinds of reasons to that religion, and I hold a conference where I say, Lord, eliminate all Christians. These are diabolical creatures. Don't forget any of them. In your opinion, would that speech be protected by the current provisions of the criminal code? And in your opinion, would that be an acceptable speech in Canada?
No, any speech that's calling for death or violence or extermination of people, that clearly constitutes not just incitement to promote hate, that's a threat, that's intimidation, and those are captured by the criminal code.
Mais quand je vous...
Okay, but when I tell you that the criminal code tells us that anyone who says in public something that encourages hatred or foments hatred and could be in prison, but if based on a religious text, it's a good defense. I know that the example I gave you seems extreme, but it seemed to correspond to what I'm reading in the criminal code. I'm basing myself on a religious text under which I allow myself to encourage hatred and incite hatred. You still make a distinction there?
Well, yes, because again, the example that you're giving is specifically calls for violence, calls for extermination. Those types of provisions exist in the criminal code that this defense does not apply to. What this defense applies to and how it has been interpreted has been in a very narrow, specific, context-specific analysis, and that's really important to look at. Now, whether it's being applied on the ground by authorities and law enforcement in a manner consistent with that strict, narrow interpretation by the courts, that's another question. That's a legitimate question. And perhaps more needs to be done to create a...
But what difference is there between what I just said and the statement by Adil Sharkawi, who said he wanted the extermination of the enemies of Gaza?
Am I able to respond to that?
No, not perhaps in a later round of questioning, Mr. Ross, but the time is up, and it's over to Mr. Bailey for 5 minutes.
Thank you, Chair. Mr. McSorley, would you agree that the definition of hatred as written in Bill C-9 were to be adopted as law, that the government or politically or ideologically motivated groups could act in a way that abuses the intent of the law?
I have to be clear. So our coalition, our organization, it does not, our expertise isn't on the definition of hate, but we do agree with those, such as the Canadian Civil Liberties Association, that have raised concerns, and others have raised concerns about whether or not the definition currently in Bill C-9 is extensive enough.
By choosing to define hatred as the government has, what, in your estimation, would be the difference between the terms disdain or dislike or detestation?
Again, I have to say that our coalition, I have to be specific because the organizations that I represent have given me a specific mandate on what to speak about. But I can say that, as we've seen with others, they would have concerns with that answer.
Mr. Ross, should the government in Bill C-9 adopt the definition of hatred as set out in the Supreme Court of Canada decision R versus Keegstra, so that the law may be evenly applied and is tightly protected from the abuse for political or ideological reasons?
Yeah, thank you very much for the question. And our written brief, and I don't know if it's been circulated yet, speaks specifically to this issue and the need for clarity in the definition of hatred. And I appreciate that the government has been very clear that the intent for this definition of hatred is to codify the established test established by the Supreme Court in cases like Keegstra and Whatcott. And we would support that. We would like to see, though, that that definition is incorporated holistically. We're concerned that a number of important parameters have been omitted. We were encouraged, though, to hear the minister invite proposed amendments to address that. And that is what we've done in our brief. And there's 3 specific prescriptions that the Supreme Court set out in Whatcott that we think need to be made explicit in the bill. And I can just very quickly identify those 3 prescriptions. The first is that hatred must be assessed objectively. So hatred is not assessed based on whether the speaker thought it was hateful or whether a complainant thought it was hateful. Thank you very much. But based on whether a reasonable person aware of the context and circumstances would view the expression as exposing a protected group to enmity and extreme ill will. So it needs to be objective. Second, the term hatred is limited to extreme manifestations. Those 2 words, extreme and manifestations, are both important and need to be added. And third, the hate speech legislation, the court said, is not to target the content of ideas, as repugnant as one might think they are, but the ways that they're expressed and the effects that they might have. So the goal is not to censor ideas or compel anyone to think, quote unquote, correctly, but to determine the likely effect of the expression on an audience. Our amendments address all 3 of those prescriptions.
Thank you, Mr. Ross. And sorry to rush you, just my time is so limited. If this bill is adopted with the definition of hatred as written, will it not just end up back in the Supreme Court to relitigate an already dealt with concern? Are we kicking the can down the road?
I think that's a very real concern, that unless these amendments are included, unless these concerns are addressed, there is a constitutional vulnerability and certainly a vulnerability to constitutional challenge.
The point in saying that this is that, there is a clear subjective element in evaluating and determining what is stronger, the disdain or dislike. Therefore, would you not agree that removing the subjective language in the definition would strengthen this bill and protect Canadians' fundamental freedoms?
Yes, precisely. That's why we recommend a clarifying clause to ensure that it's clear, not just to the courts, but to those that are interpreting and trying to apply this on the ground. What do we mean? What meets the threshold of hatred? And in our brief, it's on page 3, we propose adding language that says that for the purpose of determining hatred, the court must consider, in the view of a reasonable person aware of the context and circumstances, whether the activity in question exposes or tends to expose members of an identifiable group to enmity and extreme ill will, or seeks to abuse, denigrate, or delegitimize them to render them dangerous or unworthy in the eyes of the audience. That language is drawn directly from the Supreme Court, and we think that clarification is important and helpful.
Thank you both. Ms. Latanzio for 5 minutes.
Thank you, Mr. Chair, and I will be addressing my questions to Mr. Tim McSorley. Mr. McSorley, protecting Canadians from hate and protecting civil liberties are both very important and vital. Would you agree that having a clear, narrow definition helps ensure the law respects both goals?
I think it is very important to have a very clear definition, one that follows Supreme Court jurisprudence, and that's incredibly important to have specific language in the laws in order to ensure that the laws are applied properly.
You've emphasized the importance of freedom of expression in your opening remarks. Would you agree that even within that freedom, there must be a threshold? And we've spoken about that a few minutes earlier, where speech has become so harmful that it endangers others and therefore must be restricted to some level.
Yes, certainly we agree with that. We believe that language that would incite hatred and violence against individuals, particularly hate-based violence, that is a step too far, and that there needs to be restrictions on speech in Canada.
Okay, so if we can agree that a threshold exists, would you also agree that Parliament also has a duty to clearly define that line so Canadians know where protection from hate begins?
I believe it's a role of Parliament to set those lines. I also believe that the courts also serve a purpose for determining whether or not those meet the standard of the Charter, and we've seen that in decisions such as the Walcott decision.
But you would agree that Parliament has that duty?
Certainly, Parliament has that duty and power to engage in these debates. It's an important debate to have, an important conversation to have, and we believe that Parliament does need to be doing more in terms of addressing hate-based violence and hate speech. We just have concerns about how Bill C-9 is going about that.
So we agree that you're saying that we have our role to play, but I'm being specific. I'm saying that Parliament has a role to define and draw that line in terms of the definition of hate.
Yes, Parliament has that role and that duty, and then it's up to the courts to then kind of interpret that as well, about whether or not it is constitutional. And I think that it's important that in these discussions we determine, as the law is being made, that, we're meeting the framework of what's already been laid out by the Supreme Court.
We accept that freedom has limits when it endangers others. Isn't it also important and essential that the law make that limit explicit so that police and courts can act before words turn into violence?
Yes, certainly the law needs to be explicit, but it needs to be carefully worded and explicit in the sense of not giving broader interpretation to laws that already exist.
The definition that's in C9, what is your opinion? Is that too broad for you?
As I mentioned before, we agree with others who have said that there are concerns that the definition in C9 does not meet the same standard that's been laid out by the Supreme Court. As I mentioned, our expertise isn't on where that line should be drawn, but certainly we believe that's an issue to be debated and set by Parliament and reviewed by the courts.
So if hate can directly endanger Canadians, shouldn't government have a responsibility to draw that line clearly and not leave it to chance or interpretation of the courts?
Yes, certainly. The Parliament does have that duty and the obligation to draw that line.
Okay, so draw the line so that a court does not have to interpret or come back to that definition.
I would say that courts often, and we've seen this, for example, in our work around anti-terrorism legislation, that there is a role of the courts to be able to interpret as the law is being applied whether or not it meets the constitutional standards. And so no matter what Parliament decides, there is a role and the eventuality that a constitutional challenge could be brought. And it's justifiable just as much for the court to interpret that as it is for Parliament to set the legislation in the first place.
The line is clear from the onset, from the beginning. There would be no room for interpretation.
I would, in our experience, I would believe that that the courts, that is the setup of our system, that there is room for interpretation by courts about whether or not a piece of legislation, whether it's the definition of hatred or other definitions, meet the constitutional clearance. If it doesn't, then the courts will rule, and then it will be up to Parliament to review that ruling and bring in changes to the legislation to ensure that's constitutional.
Hate crimes often silence voices. So how can clear laws like this empower those voices?
Ms. Latanzi, we won't have time for an answer. Unfortunately, we have to move on to the next. Sorry. So, friends, we'll have time for a full third round. I may have to chop the last two speakers by a minute or so just to ensure proper transition to the next round. But we have MP Lawrence to start it off, MP Chang, Monsieur Fortin, now Mr. Lawton, and then Ms. Dillon to close it off. MP Lawrence, over to you for 5 minutes.
Thank you. First of all, just want to affirm the important work I think this committee is doing, and thank you for having me here. Certainly, fighting hate is amongst the most important things we can do in Parliament, so really do appreciate it. And on that nonpartisan spirit, Ms. Latanzio, if you want to finish off to get the answer from the witness, I'm willing to donate 30 seconds of my time there.
Mr. On that, Mr. McSorley, so I'll pursue my last question. So hate crimes often silence voices, and how can clear laws like this empower Canadians to feel safe expressing their views?
I believe that is the gist of our argument, is that there needs to be clear laws in order to ensure that people can express their views from all communities. There's a clear need for legislation that governs hate speech, and especially violence that's inspired by hate. But at the same time, we believe that the legislation needs to be precise, and we think that there are areas of Bill C-9 that need to be given further precision in order to ensure that it's not applied in overly broad ways that could in fact lead to those who are speaking out and expressing their freedom of expression rights from being criminalized.
Thank you. I just want to. I think it's been some excellent testimony as to some of the weaknesses of the bill, and I think it's been constructive. So I just wanted to take the conversation though a little bit back, more general. So, a quick but I think important question for the witnesses: do any of you know how the Charter of Rights and Freedoms begins?
If you're referring to,
sorry.
Are you referring to the? Sorry to interrupt you. If you're referring to the preamble?
You referred to the preamble, although it's actually a part of the Charter. It's not actually a preamble.
So the opening words of the Charter state that whereas Canada is founded upon principles that recognize the supremacy of God and the rule of law, and then Section 1 states that the rights and freedoms are guaranteed subject to such limits. I should have this memorized as can be justified in a free and democratic society.
Yes, and so I just wanted to ask all of the panelists, we'll just use the three major books, or three of the major, shouldn't say the three major, but three of the major books of religions: the Quran, the Bible, both New and Old Testament, and the Torah, which of course is the first 5 books of the Old Testament. Do you believe that any Canadian should ever be criminalized for reading any of these scriptures? And we'll go right across. So start with you, Mr. Ross.
No, there should not be a categorical criminalization of simply reading a religious text. As I hope I made clear in my previous answers, sometimes the context of the way that a text is used, or more accurately misused, that might merit criminal intervention. But to say categorically that reading a particular text, whether it's a religious text or any other text, I think it's problematic if we start listing certain books as being off limits.
Deputy Chief.
Yeah, I agree. I think no. I mean, reading is one thing. I think it's the context it's being read in, and the space it's being utilized in. I think is something you need to be mindful of, right? Anyone can read what they want and choose to read what they want and believe in what they want to believe in. It's a matter of how you're utilizing that, whether in a space amongst your peers or your friends, or in a space where there's others who might have some concern with that. So I think that the context is very important around the use of that.
So, but Deputy Chief, if in fact you're reading the Torah, the Quran, or the Bible in a large group, you might see a potential for criminalization.
No, again, that's I think far-reaching a little bit. I think it just depends on the context of what your intentions are with it. I mean, you could get into good debate about the use of that and when it's used, but to read it, I think we could read lots of things that people might find offensive, right? So I think there's a context that you have to take this all in when you look at what the intent of that was.
The same question for you.
Thank you. Yes, and I'd agree with the two other speakers that certainly there should be no law that simply outright bans the reading of any religious text in Canada, and that the context of how speech is delivered is what is important. And if it goes into calling for violence or other similar instances, then certainly that needs to be addressed. But the simple reading of a religious scripture should not be criminalized.
Mr. McSorley.
Mr. Lawrence, sorry.
Thank you very much. Thank you, Mr. Chair. You're very kind.
MP Chang, over to you for 5 minutes.
Deputy Chief, thank you for your time. Across Canada, we have seen a troubling rise in hate targeting marginalized groups and queer and trans people in schools, in community spaces, and online. So marginalized groups and US LGBTQI+ Canadians are often targeted by hate that can escalate from verbal harassment to violence. How can Bill C-9's clear definition and stronger enforcement tools help officers intervene earlier to protect vulnerable people in Canada?
Thank you for the question. I think just, again, as I've said earlier, I think having a clear definition allows for our police officers to have a better understanding of what they're dealing with in the moment, rather than trying to seek out interpretation from maybe a peer or someone who specializes in this area. So it just grounds us in what we're dealing with, and allows us to act or intervene if needed earlier. Of course, continuing on with any investigation to decide whether or not we have reasonable probable grounds. And then working with Crowns or otherwise in order to get to that likelihood of conviction, whether the charges are laid.
Thank you. And building trust is essential. So what steps can police services take alongside legislation like Bill C-9 to ensure marginalized groups and US LGBTQI+ Canadians feel safe reporting hate incidents and confident that they are taken seriously?
Well, I think there's a couple things. By having some of this legislation put in place, I think allows us as a police service to properly report on what we're seeing and what we're dealing with. I think right now, because it is a bit gray in some of these spaces, and we're not seeing these charges being laid in spaces that are maybe under a mischief, for example, it's not accurately capturing what we're dealing with. Right now we're left to search reports for doing keyword strokes to look for language within our reports to identify if someone has been potentially, a hate incident or a hate crime has been committed. And again, the more that as a police service, we can support and represent all of our communities to have safe spaces to do what they want to do each and every day, and have those parameters around that, I think just builds trust with our communities, and sets the standards for what the expectation is about how we interact with each other.
Thanks. And partnership makes prevention stronger. So how can collaboration between police and marginalized groups and US LGBTQI+ Canadians improve education, reporting, and support for victims of hate-motivated crimes?
I think anytime as a police service that we can respond to the needs of our community, regardless of who they are, and that they see that we're taking what their concerns are seriously, and we're communicating and working with them, regardless of what the outcome is in the situation, whether there are charges laid or not. It all comes down to public trust. The more public trust we have with our community in regards to them seeing us being that impartial individual in that space to make sure we're managing what's going on, I think just builds better community trust, allows us to get more reporting. And we've seen some of that growth with reporting. And that's going to be work that's done specifically agency by agency in the relationships they have with their communities to ensure that there's open dialogue around what the needs are and how we best represent them.
Thanks. Do you agree that the definition of hatred in Bill C-9 can be assessed objectively?
Yeah, I think whatever the definition comes to be having a definition of hate crime is going to assist police. Anytime we have something as police officers to make our jobs easier, to make sure we know what we're doing, it takes away that impartiality around people interpreting things erroneously and maybe acting inappropriately based on what their thoughts are. Having that definition, I think, just puts us within those guidelines about what helps us do our jobs every day.
Thank you very much. And my final question is, Bill C-9 also reaffirms that legitimate debate and discussion are still protected. Do you think that kind of clarity help bring people together?
I absolutely think. I think these kind of things help people. I think there's going to this is going to create a certain level of comfort for people to understand that we're all working in the same to meet the needs and to create some definitions and parameters on what this is and what this means to us as Canadians, our role as police officers in this space. And anytime we can have any conversation around this to set those standards, both good, bad, or otherwise, is very important.
Thank you very much.
20 seconds, so pretty much so. We're done. Monsieur Fortin, 2 minutes et demie à vous.
Mr. Fortin, 2.5 minutes for the first turn? Okay. Thank you. My question is for Mr. McSorley. Mr. McSorley, C9 anticipates that preventing access to a place, there are already prohibitions of this nature in the criminal code. This is being added. In your opinion, will this be in conflict with the right to demonstrate? For instance, students in a CEGEP who want to demonstrate, regardless of the reason. The fact of demonstrating on the land of a university or CEGEP be against these new prohibitions? Yes, I will answer in English. I speak French, but I want to be very specific here.
I would say that there are significant concerns around how the new obstruction and intimidation provisions could impact protests in general. There's concerns around whether or not a space within a campus that may be for a religious or cultural purpose that would be protected under this legislation could be interpreted to apply to a broader aspect of the university or the campus. And so that's something that we think needs to be more specifically addressed and regarded. The other concern that we have is that we know that spaces that may be devoted to and used by a particular community can also be used for a wide range of areas, and that's reflected in bubble zone bylaws that have been shown have been set to apply to the regular business of a certain of a place of worship or a cultural center. And so we would be concerned about a blanket application of a block on the right to protest, because it could be non-religious or activities not related to the nature of the protected nature of the building that would then be blocked that would then block the ability for individuals to engage in protest.
Si je comprends bien, les interdictions qui existent présentement.
So the prohibitions that exist right now in the criminal code to not obstruct entrance are sufficient.
Donc cette partie.
So that part of C9 should not be adopted, if I understand your opinion correctly.
No, we do not believe it should be adopted.
Merci. C'est fini.
Thank you.
Mr. Lawton, over to you. We'll do a full 5 minutes for you, and then Ms. Dillon.
Thank you very much. Mr. McSorley, when we were speaking earlier, I was hoping I'd be able to dispatch with my questions very shortly, but evidently this is going to take a little bit more time here. You identified in your testimony a key concern you had with the provision of C9 dealing with hate symbols to be what you termed a flawed process in listing terrorist entities. So if you believe the process is flawed, do I take from it that you believe there are people on the list of terrorist entities that do not belong there?
That's a good question. We believe that the process is flawed. We haven't, our role, and we have not reviewed every single entity that's on the terrorist entities list to determine whether or not they should be there. One example I could give is that the FARC in Colombia was previously a revolutionary force engaged in violent activities, is now part of a peace process, and yet remains listed on the terrorist entities list. And so we think that's part of the flaw in the fact that it's difficult for organizations to challenge it because it's done in, the evidence is kept secret and the decision-making process itself is secretive. We think that administrative listing processes are the problem. The government can determine whether or not there should be sanctions against certain organizations for the activities they undertake, including organizations they deem to be terrorist organizations. But we are deeply concerned around how the listing process itself works.
Do you believe that ISIS belongs on the list?
Again, they've engaged in terrorist activities. They engage in violence. We believe that the government is right to set sanctions. We don't believe in the actual listing process as being an effective tool.
Do you believe Al-Qaeda belongs on the list?
Again, the same answer. These are terrorist organizations that engage in violence and should be sanctioned. We have problems with the listing itself.
Thank you. You just acknowledged that ISIS and Al-Qaeda are terrorist organizations. How about Hamas?
Hamas has also engaged in activities that have been defined as terrorist activities. We believe that any act of political violence is problematic. The government has decided to determine that they are a terrorist organization, and we have problems with the actual listing itself.
So I'm just struggling to understand here where you would draw the line when we are talking about organizations that have committed in plain view acts of terror, that have as their charter a desire to eradicate the Jewish people and the Jewish state. And I have, anyone who's watched my work on this committee knows that I am a very firm believer in freedom of expression. I've been very critical of Bill C-9 for, I believe, infringing on that. But if we are not able to have a conversation that calls terrorists terrorists, I don't see how we're going to be able to deal with some of the bigger questions facing this committee and facing society. So this is a very simple question. Do you believe October 7th was a terrorist attack? Not how governments view it, not how the Canadian government is viewing it. Do you believe it is a terrorist attack?
I believe that it was an act that would fall under the definition of terrorism. It was a terrorist activity, but we have problems with how the government views how Hamas or any organization is placed on the list, and that the listing process itself is a problem. And that the definition overall that simplifies the idea of what's considered terrorism leads to discrimination and leads to the tarring of entire communities engaged in protest, for example, against human rights abuses as being linked to a terrorist organization.
Do you believe that if someone were to gather in a Canadian street and say we should have another October 7th, would that be an incitement to violence? Would that be something that you believe should be criminal?
A call to the reenact to again engage in a violent activity is clearly a call to violence, and it would be criminalized.
I'm glad we got eventually to your position that this was terrorism. Thank you very much, Mr. McSorley. Just in the limited time I have left, I'd like to ask you a question or two, Deputy Chief, because we have seen the definitional changes in C9. Are there hate charges that the Edmonton Police, or potential hate charges that the Edmonton Police Service has not laid in the last year, 2 years that you're aware of that would be laid if C9 had been in place?
I would probably say yes, that there probably would be. And I think part of the problem is that we've gone with mischief charges because there wasn't an actual charge for that space, for that particular charge. So I think that's where we're going to see some of those mischief charges coming up, because we would have felt that we could have advanced with the hate crimes charge, and it just didn't exist with that definition.
There was, in a community in my riding, someone who was charged under 319 with hate, and their display had involved a swastika mowed into their lawn. Do you agree that hate symbols can be a part of your investigation and your decision to lay a charge under the current hate laws?
I think they're considered. I just don't think it's as clear as we'd like it to be.
Thank you. Thank you, Deputy Chief. Thank you, Mr. Lawton. Ms. Dillon, to close this off for 5 minutes.
Mr. Chair, and my questions will go, and I'm going to share my time with MP Housefather. My questions for the moment are with Deputy Chief Chapdelaine. When hate crimes go unaddressed or delayed, it can leave victims feeling unheard. How important is it that legislation like Bill C-9 gives police the tools to act quickly and consistently across the country?
I think it's very important. I don't think there's any other way to say it. I think it's very important because I think the response that we give our communities is something that we are measured on every day.
Officers are the first point of contact for victims of hate. How would having a clearer definition and stronger provisions under C-9 help improve confidence in reporting these incidents?
Again, I think it's like we say, we have to build trust with our marginalized communities and provide accessible reporting for these kind of events. And so I think having these additional this additional legislation available to us just continues to help us build that trust with our communities in regards to our ability to respond to the needs.
In the last years or even recent past, have you seen a big increase in hate-motivated crimes?
So I can say, and I have the numbers in front of me here, we've witnessed a troubling increase in Edmonton in hate incidents across, Edmonton and across Canada. In Edmonton, 2025, hate incidents rose to 125 year to date, up from 91 in the same period in 2024. And hate crimes have slightly decreased. But the rise in incidents reflects both an increase in public awareness and growing concern within our communities.
So public awareness has helped to, I guess, have an impact a little bit on hate crime.
Correct. The way we work with our communities and try and work with them to bridge those barriers for them to report and have trust in our organization to take these issues seriously. As with anything we do, we'll increase reporting, but I think that helps us better understand what we're dealing with in our community.
And I wanted to thank you before for working so empathetically and sympathetically with those who are victims of hate-motivated crimes. It's very comforting to see police officers such as yourself, and I have utmost gratitude and appreciation for you. Thank you for coming to committee today, and I will give over the time to MP Housefather.
Thank you, MP Dillon. Mr. McSorley, in October 2024, Samadoun was listed as a terrorist entity. Do you agree that Samadoun should have been listed as a terrorist entity?
As I mentioned before, we don't take a position on whether or not, and we haven't examined every single organization that's listed on the terrorist entities list. Our concern overall is around the process for listing Samadoun.
But some of the organizations you have listed on the list of organizations you're here representing have partnered with Samadoun in creating events, including Independent Jewish Voices, for example.
Our members are available and are able to engage in their own activities. We don't take a position on what activities they specifically have taken.
And when Charlotte Cates, the head of Samadoun, led a cheer of Long Live October the 7th and praised Hamas, would that be something that you think is reasonable to do in Canada?
Personally, I don't believe in any calls to violence, and so I would have trouble with that particular chant.
But what about praising Hamas at a public rally?
I think praising an organization like Hamas in order to call for more political violence, I think is incredibly problematic. In Canada, speaking from the position of our organization and from the law, in Canada it is not illegal, and I believe there could be a debate around around the discussion and the presentation of terrorist organizations in public spaces, but it isn't a criminal activity to say something like that. Personally, I would not call for something like that. I would not say something like that, and any incitement to violence.
What about globalize the Intifada? What about globalize the Intifada? If people are screaming globalize the Intifada at a public rally, would you say that crosses a line?
Intifada can have multiple definitions. There haven't only been violent intifadas. I believe it would have to be taken in the context of the way it's being said. But if it is done in a context of calling for violence against individuals, then I would be opposed to it, clearly.
Thank you. I appreciate your direct time.
Thank you.
Thank you, and thank you to all witnesses for this very interesting conversation. Thank you for the time that you took today to appear at the committee. And I wish you well. We'll take about 5 minutes break to switch over to the second panel. Thank you. Bonjour à tous et à toutes.
Good afternoon again. For the second hour of the Justice Committee, I will dispense with my lengthy introduction with all the instructions. Those who are online must know that they have to use the interpretation function. They should be familiar with that in Zoom. Those in person, try to spare our interpreters and not speak too close to the mic. Be about a meter away from your microphone. That would be a good idea to help these faithful interpreters who provide the testimony in both official languages.
We have from the Association for Reform Political Action, John Sikema, Director Droits et Politiques du Barreau du Québec,
Marcel Olivier Nadeau from the Quebec Bar, Nicolas Saint-Jacques, and Eva Sigora, who are all here from by video conference.
Vijay Kumar Jain, Director, welcome in person. Et du Centre consultatif des relations.
And for the Israel and Jewish Affairs Center, Noah Shack. Welcome, all of you. Each group has 5 minutes for their preliminary remarks. There are 4 distinct groups, 20 minutes of testimony maximum, so please try to be concise. So without further ado, I'll give the floor to Mr. Sikema for 5 minutes. I thank Mr. Fortin and others. Sound tests have been done.
Mr. Sikema, up to you.
Thank you, committee members. It's my privilege to appear on behalf of the Association for Reformed Political Action, or ARPA, where I serve as legal counsel. Thank you all for your thoughtful review of this bill. My remarks today will focus mainly on the hate propaganda provisions of the bill, but our written brief, which you may not have yet, also addresses the proposed hate crime and the intimidation offenses. ARPA is a Christian, nonpartisan policy and legal advocacy organization with considerable experience as a friend of the court in charter cases. ARPA believes that every person has inherent dignity as an image bearer of God, and that we have a moral duty to honor each other's reputations. That duty is reflected in our laws on defamation and criminal libel, among other areas, and that moral duty applies not only in relation to individuals, but to groups as well. Legally, however, group libel is more complicated. One danger, as our Supreme Court has identified, is that laws meant to stop malicious attacks on a group's reputation and basic social standing could be used to silence criticism of beliefs or practices associated with the group. So let me illustrate the difference. The late atheist wit and writer Christopher Hitchens called the Christian doctrine of vicarious atonement evil. Now, that is a core Christian doctrine. But Hitchens was expressing a moral and, one might even say, theological opinion, and he was rightly free to do so. Yet today in Canada, people are being accused, often by government officials, of promoting hatred simply for expressing moral or political views. My own organization, ARPA, was accused by the mayor of Hamilton for promoting hatred because we put up a sign that said, "Let kids be, end medical transitions for minors," and the city had it taken down. The city also claimed that another sign from a different group, which said that women are by definition female, also had to be censored due to hate speech concerns. Earlier this month, the British Columbia legislature condemned ARPA as hateful for opposing medical transitions for minors and for supporting moderate pro-life laws. A BC government MLA even told a story, a very sad story, about a same-sex couple being harassed in a public place, and then called ARPA and its supporters the harassers in that story. Blatantly false, but I guess justified because Christians hold the traditional view of marriage. Now, the member's statement, to be clear, defamed and vilified Reformed Christians as criminal harassers, which seems like a way, frankly, to stir up hatred against this group, while at the same time accusing these Christians of promoting hatred for the views that they hold. I trust I don't need to point out the hypocrisy. This kind of ideological bias is what the Supreme Court warned about in Keekstra, and which Parliament must guard against here. Bill C-9, with respect, risks blurring the long-established definition of hatred. If the goal is simply to codify the common law, then the bill should mirror the stringent tests set out in Keekstra and Woodcott. Those cases caution against 2 key errors, among others. First is focusing on the content of what is said rather than its anticipated harmful effects. And the second is focusing on the feelings or views of either the accused or the victim group. Bill C-9 risks both errors. First, it uses hatred in one place to refer to the feelings that the accused intends to promote in others, part of our established test. And in the new hate crime offense, it uses hatred in reference to the accused's own feelings and motives. Second, the bill's clarification clause blurs whether courts should consider the feelings or views of the identifiable group by using the words solely hurting, humiliating, or offending. ARPA therefore recommends that the committee either remove both the definition of hatred and the clarification clause to make clear that the common law standard still applies, or amend both to clearly reflect Keekstra and Woodcott. Hatred could simply be defined as an emotion of an intense and extreme nature that is clearly associated with vilification and detestation. The clarification clause could say that it is, a statement is not criminal because it is considered offensive, repugnant, or distasteful, or because it ridicules, belittles, or affronts the dignity of a group. And those are both phrases taken from Keegstra and Whatcott. Because of the analytical pitfalls I have noted here, and others that the court has warned about, and that you've heard other witnesses highlight, the requirement for Attorney General approval should remain. As an intervener in a hate speech case, I noted the Crown making some troubling arguments, again, going to the substance of the views, the person's moral views, rather than what they're trying to promote, right? The emotional reaction they're trying to promote in others.
Mr. Kimmy, you're at time. If you could just briefly wrap up in a few seconds.
For sure. Our main concern is that the bill set a sufficiently clear standard to protect groups from deliberate, vicious libels without creating a potential weapon for ideological censorship. Thank you, Chair and members.
Thank you. Maintenant au barreau du Québec pour 5 minutes.
The Quebec Bar Association for 5 minutes. Thank you. Can you hear me? Yes. Thank you, Mr. Speaker, or Chairman, rather, for having invited the Quebec Bar to testify on C9. Usually, these hate crimes are based on race or ethnic origin, so it's essential that the bill provide the courts with effective tools to combat these crimes while ensuring that they comply with the principles of fundamental justice and Canadian constitutional requirements. Bill C9 is a continuation of Bill C63, tabled in February 2024, on which we made recommendations. We're pleased that some of these recommendations have been taken into account, in particular, the removal of life imprisonment for hate crimes. Overall, Bill C9 presents a more nuanced regime than in the past in Bill C63. That said, several fundamental questions remain, and the Quebec Bar wishes to once again contribute to the discussion on these essential issues. Let us begin with the definition of hate, which we believe is essential to codify. On the one hand, this will encourage reporting by allowing communities to clearly understand what is prohibited, and on the other hand, it will keep all stakeholders, including police, to act within well-defined rules. However, we have reservations about the definition of the term hate proposed in the bill based on the Whatcott decision. In that case, the Supreme Court of Canada ruled on the constitutionality of a provision prohibiting hate publications in the context of human rights. We submit that in criminal matters, the key decision is the Keegstra ruling, which was revisited in the Mugesera ruling in 2005. In these decisions, the Supreme Court interpreted the concept of hatred specifically in relation to the provisions of the Criminal Code and find that it denotes an intense and extreme emotion that is clearly associated with vilification and loathing. Therefore, in order to avoid the risk of challenging the constitutionality of this provision, considering that the burden of proof in criminal law differs from the applicable in civil law, we suggest that the bill adopt the latter definition. The bill then makes it a hate crime to commit an offense under the Criminal Code or any other federal statute while motivated by hatred based on certain factors. We invite the legislator to reconsider the introduction of this new offense into the Criminal Code, which has the effect of creating a prosecution regime parallel to the one in use. In fact, the current provisions of the Criminal Code already allow for the prosecution of hate crimes, considering the motivation of hatred at the sentencing stage. The new provision proposed by the bill proposed a paradigm shift by making hatred a constituent element of the offense itself. We question the relevance of creating a new regime for prosecuting hate crimes which would coexist with the current one. For the reasons set out in more detail in our brief, we believe that this is an ineffective measure that could undermine the principles of parity and harmonization of sentences. The Barreau du Québec proposes instead to enhance the existing provisions of the Criminal Code by improving sentencing tools in order to achieve the same objective, namely to crack down on hate crimes. Finally, we would like to point out that 3 of the new offenses proposed in the bill are likely to raise issues of compatibility with the exercise of fundamental rights guaranteed by the Canadian Charter of Rights and Freedoms. On the one hand, the new offense of willfully promoting hatred by displaying certain symbols in a public space may restrict the right to freedom of expression. On the other hand, the two new offenses of intimidation relating to access to a building used for religious worship may restrict freedom of expression and freedom of assembly. Although the courts recognize that these fundamental rights are not absolute and may be restricted, such restrictions must be minimal, proportionate, and accompanied by sufficient safeguards. It is not solely up to the courts to ensure that this balance is maintained. It is also up to the legislator, when drafting the provision, to clearly define the scope of the offenses and the defenses in order to achieve the objective of cracking down on hate crimes while minimizing the risk of constitutional challenges. With this in mind, we recommend that legislators remain attentive to the comments made by various groups that will be here during consultations on the bill. These stakeholders, particularly fundamental rights advocacy groups, will be able to present concrete examples illustrating situations in which the new offenses could interfere with the legitimate exercise of protected rights. Following these consultations, we believe it would be appropriate to conduct a further review of the scope of the new offenses and the exceptions provided for. This exercise, based on the comments gathered during consultations, could help to better define the application of the new offenses and ensure their constitutionality. Further comments can be found in our brief. We are now available to answer your question. Thank you very much. Thank you, Mr.
Indo-Canadien pour l'harmonie. Thank you. Thank you, Mr. Chair, for giving me an opportunity to come here and share our concerns about the Bill C-9 on behalf of Hindu and Jain communities. I have made a written submission which is under a French translation at the moment. And I have submitted a letter which has been co-signed by 70 plus Hindu and Jain community organizations across Canada. I'm here to raise two concerns with the bill. The first one is pretty much the usage of the word swastika in the hate references in this bill. First, before I start, I must say that we support all the efforts of the Government of Canada to address the hate crimes in Canada. We stand in solidarity with all the communities, including Jewish communities, who are facing hate crimes in Canada. At the same time, we welcome the usage of facial neutral terminology such as any identifiable groups in Section 2.2 in the bill, which shows that the bill intends to address hate against all of the identifiable groups, including Hindus. However, our concern has been the usage of the word swastika in hate references and its association with Nazi in this bill. Swastika, as you know, is a Sanskrit word, and its meaning is prosperity and well-being of all. The word is used extensively in Jain, Hindu, and Buddhist religious texts, prayers, and rituals. Usage of swastika word in hate references deprives Jain, Hindu, and Buddhist Canadians their religious rights to use the word in their prayers. Now, when it comes to this association with Nazi, so let me make it a little bit academic exercise. So there is no swastika word in Latin or its derivative European languages. Hitler and Nazis never called their symbol as swastika. Their word was Hakenkreuz or hooked cross. And we understand that in this bill, the word is used as Nazi Hakenkreuz, which is good. However, at the same time, in this bill, there is an association of the word swastika with Nazi. So associating the word swastika with Nazi symbol or anti-Semitism spread misinformation and confuses Jain, Hindu, and Buddhist learners about their scriptures. Now, we have a deep concern about associating the swastika word with Nazi. And we have approached many organizations, many provincial government to remove the swastika word from the hate references. And in my written submission, I have provided all the examples, around 8 examples we provided, where provincial government, the regional government, as well as the police in variety of places has removed, and leading Jewish advocacy groups has removed the swastika word from hate references, and they use the correct term the Nazi Hakenkreuz, which should be banned. Also, I gave example of other places, Victoria State in Australia, where they made the legislation and they have what they banned is Nazi Hakenkreuz. However, they made explicit exception for the swastika word and how it should be used. Now, what we are recommending as a community, we recommend the change of the wording in the Bill C9 under Section 2.2, where in Section B, it says that the Nazi Hakenkreuz, also known as the Nazi swastika. So we recommend to remove the Nazi swastika word from that section. Further, we understand the bill intends to cover exception for the usage of swastika for religious purposes through defenses under subsection 2.2 in 3.2a. However, these generic wording are not sufficient enough considering the widespread conflation of the word swastika and the lack of awareness. We request to add explicit exception as done in the legislation in Victoria State in Australia. And I quote it, "The exceptions for the cultural and historical significance of the swastika to Hindu, Buddhist, Jain and other faith communities remain unchanged. It is not against the law to publicly display the swastika, which may be mistaken for the Nazi Hakenkreuz symbol for genuine cultural or religious purposes," unquote. Further, we recommend the federal government to educate communities, police personnel, and media to use the correct terminology. The above measure should address the concern of Hindu and Jain communities. Thank you, Mr. Chair, and the committee for hearing our first concern. If time permits and if the chair approves, and if I have a minute, I can present my second concern. Thank you. Now, we welcome the bill where it has the facial neutral language that we are addressing the hatred against all identifiable groups. However, when the communication was sent out from the Justice Committee on September 19, 2025, what it makes an explicit note of addressing anti-Semitism, Islamophobia, and homophobia. However, it excludes Hinduphobia word in the communication. There has been rising Hinduphobia incidences in Canada, and when such communication goes out and we see that the Hinduphobia word missing from there, our community feels that the hatred against Hindu community has been ignored. We request to include the Hinduphobia word also in such communication. Thank you, Mr. Chair.
Thank you, Mr. Jain. Mr. Shack, on behalf of CJA, welcome, and please go ahead for 5 minutes.
Thank you. I'm grateful to be here with you today, representing vibrant Jewish communities across Canada that contribute immensely to Canadian society, advocating for a brighter future for Jewish communities and all Canadians. Since the Hamas-led terrorist attacks on October 7th, we've witnessed an alarming surge in hate, extremism, and violence across Canada. Numbers alone cannot capture the full picture of what we're facing. Schools shot at, synagogues firebombed, community members stabbed, assaulted, terror plots targeting our community. And these are not isolated incidents. They're the result of growing extremism, open support for terrorism, and radicalization. What was once confined to the dark corners of our society is now found on our streets, in our workplaces, in schools, on university campuses, and in our neighborhoods. No less concerning has been the erosion of trust in our justice system and in the ability or willingness of our institutions to hold those who break the law accountable. It shouldn't take a catastrophic tragedy for authorities to act against those fanning the flames of violence in our country, the kind of violence we saw recently in Manchester, Boulder, and Washington, D.C. The terror plots uncovered in Canada should make it clear that we are one intelligence or law enforcement failure away from a horrifying incident here at home as well. This is why we are urging parliamentarians to set aside partisan differences, work together towards consensus, and refine this bill to maximize its impact. This is essential not only to strengthen our laws, but to send a clear message to Canadians about who we are and what we must do to safeguard this incredible country that we share. Action is needed to address the hate, harassment, and intimidation that has targeted our community over the last 2 years. In Montreal, an aggressive mob of anti-Israel demonstrators blocked the entrances to the Jewish Community Centre, damaged property, yelled death to Jews, barricaded 100 community members inside with no one permitted to enter or exit. The police did not remove them. Here in Ottawa, anti-Israel activists gathered not outside the Israeli embassy, but outside a seniors' residence at the local Jewish community center, a home for Holocaust survivors and seniors with dementia. For hours, family members attempting to visit their loved ones faced protesters screaming, "Go back to Europe," and "We want bullets and missiles." Police did not remove them. In Toronto, hundreds of anti-Israel protests have blocked commuters, public transit, even emergency vehicles, at which symbols of banned terrorist entities have been proudly displayed. Police arrested an individual for flying the flag of a banned terrorist group, the Popular Front for the Liberation of Palestine. But charges were withdrawn by the Crown because, quote, "It cannot prove the mental element of this offense, namely the intent to incite hatred against anyone or group by displaying this flag." A Toronto man charged with 29 criminal counts, including promotion of genocide, arson, vandalism targeting the Jewish community, found in possession of multiple firearms, loaded firearms, and a switchblade knife. He was immediately granted bail. Enforcement matters, but without clear laws to drive consistent enforcement, we can expect more of the same and even greater threats to public safety. We welcome Bill C-9 and recognize the need to improve key aspects. With the right amendments, the bill can achieve its objectives and earn broad consensus support. Specifically, we urge committee members to consider the following. The creation of a standalone hate crime offense rightly makes hate motivation an integral element of the crime, not merely a factor considered at sentencing. This provision should be added to the list of offenses that trigger reverse onus and bail hearings, ensuring that hate motivation is considered at bail to protect Canadians from high-risk offenders. But it's not a replacement for the existing hate mischief provision, which applies to offenses motivated by bias, prejudice, or hate, and which is regularly used as an effective tool by police. The repeal of this provision would deprive law enforcement of that effective tool, requiring a higher threshold for enforcement, and it should be retained. C-9 rightly codifies a definition of hate, but this definition should mirror that established by the Supreme Court of Canada for both clarity and consensus. Attorney General consent for hate propaganda offences too often result in cases disappearing into a black hole, eroding trust in and functioning of the justice system. But the intent of this safeguard has merit. The committee should consider alternatives to complete removal that would streamline the process, advance transparency, timeliness, and accountability, and guard against vexatious prosecution. Finally, we welcome the bill's intent to address the display of terror symbols. These symbols inherently promote the hateful violence of listed terrorist entities and should be prohibited, period. We recommend the addition of a willful promotion of terrorism offense that would address the concerning radicalization we're seeing across the country. Thank you very much.
Thank you. Members are familiar with the format. We'll start off with Mr. Lawton, then Mr. Chang, ensuite Monsieur Fortin. In the second round will be MP Lawrence, Latanzio, Fortin, Brock, and Housefather, and then we'll have to do some chopping at the end for a third round, but we'll probably get the balance of it in. So over to you, Mr. Lawton.
Thank you, witnesses, for taking the time to join us today. I'd like to start with you, Mr. Schack. In November of 2024, CJA wrote a letter to the government in the wake of rampant anti-Semitism across the country, riots even, and there were 5 actions in it. Now, I won't go through them all in the interest of time, but I'd invite you to submit a copy to the committee for our review later. But I noticed that nowhere on that list of action from the federal government was the removal of Attorney General consent on prosecuting hate crimes, changing the definition of hate, removing religious protections that exist under Section 319. Even the, some of the other measures of C9 were not in there. What you asked for in that letter was strengthen the enforcement of existing hate crime laws. Do you believe there has been an enforcement problem in the last 2 years with Canada's existing laws surrounding hate and intimidation and mischief as they pertain to your community and your members?
The examples that I cited in my testimony speak to an inconsistent enforcement of the law, and I think that provisions within this bill would help to clarify and focus law enforcement in some crucial areas. As I mentioned, our position is that the status quo with Attorney General consent is not functioning. It's not functioning as it should. the system would benefit from clear guidelines and requirements and transparency to ensure that attorneys general are engaging with these crimes and these cases with the seriousness that they merit and not allowing any political considerations to enter the fray, and that they would move forward quickly. The alternative to that, of course, is ensuring that private prosecutions still benefit from Attorney General consent to ensure that those are not abused.
I'm glad you mentioned that, because I know that CJA has been subject to incredibly defamatory accusations of basically defending genocide by virtue of being a Zionist organization. I know Jews have found themselves on lists by activists that have been accusing them of a great many things. Is there a concern on your part that lowering the threshold for hate, making it easier for hate charges to be laid, is going to allow the process to be weaponized against Jews, weaponized against the very people that some of the supporters of C9 are purporting to want to protect?
So, as I mentioned, the Attorney General consent provision is there for a reason, and that reason has merit. But unfortunately, the way the system is operating, the status quo is untenable. So there needs to be a change. Whether that change is to provide further clarity and transparency and timeliness to the consideration of hate promotion charges, or whether it's to remove it altogether and ensure that it still remains in place for private prosecutions, that's something that this committee needs to dive into. The status quo is untenable, but we need to be very careful about how we move forward.
Mr. Stickema, you mentioned a few examples in which your organization, ARPA, has been subject to either through media discourse or political discourse, accusations of hate. And we have talked about this before this committee before, the concern that, especially in light of how various human rights commissions in Canada have tried to redefine this, and now the government lowering the threshold, that we are going to end up in a situation in which people that may have a view on, perhaps gender and sexuality for whatever reason are going to be targeted by this. Is that a concern you see the way C9 is written?
Concern. I certainly think it's important to distinguish between the criminal context and the human rights context, as a representative of the Barreau de Quebec, I believe, did. However, as we've seen with Keekstra and Whatcott, the court will use the same definition of the term. So even if the intent requirement is different, the same definition of the term can apply, and then that can have downstream effects. So even when it comes to cities saying, you can't say that, you can't post that advertisement, that kind of thing, they will refer to, well, our advertising policy municipally says you have to comply with the criminal code. Obviously, they're not even claiming to prove that to beyond a reasonable doubt. They're saying it looks like to us that might be hate speech, so that we can censor that. So it can have downstream effects if at the federal level in the criminal law you're going to soften loosen the definition of hatred.
We've heard some very contradictory lines from the Liberal government on this in the course of our committee's work. The Justice Minister said there is no redefinition. This is simply codifying the definition that exists in the Supreme Court jurisprudence, despite the changing in language. Earlier in today's meeting, Ms. Latanzio had said to the contrary that Parliament has to draw the line there. So that indicates that there is a new line being drawn and not the one that is on the Supreme Court. So just to confirm, is your position that the Justice Minister's claim that what is in C9 in defining hate does not constitutes just a replication and a codification of existing jurisprudence? Is your position that that is a misrepresentation of his own bill?
The minister may mean that, I think that's there's maybe an attempt to summarize the law. And we, in our written brief, which, again, I don't think is before you, have cited some cases where the courts have said, look, we're not going to assume that Parliament's trying to change the common law unless there's a clear signal to do so. So I expect if this is litigated, people are going to be citing the minister's statement, really hoping that is true. But the most important thing the court looks at, of course, is the text of the bill, which all of you get to vote on. You don't get to vote on what the minister says, or you get to vote on the text of the bill. And so, again, if that is indeed the government's intention, to me, it seems like it shouldn't be a partisan issue to just make that more clear. Obviously, your job is a bit different than the courts, but again, if that is the objective, just a few tweaks there would signal more clearly that this is the standard set in Keekstra in that criminal case.
Thank you. Thank you, Mr. Chang, for 6 minutes.
Thank you, Chair. Mr. Sigma, we have seen far too many examples of across Canadian communities, including Jewish, Muslim, queer Canadians, facing threat to their safety and security. Bill C-9 represents a strong national stand that hate has no place here in Canada, and that our laws must give law enforcement the clear tools to act when it does occur. So, marginalized group and 2S LGBTQI+ Canadians continue to face some of the highest rates of hate-motivated incidents in this country. Would you agree that by maintaining a clear, narrowly defined legal standard for hate, Bill C-9 help ensure that these communities are protected without infringing on legit moral or religious expressions?
I do agree certainly with the importance of doing that. I think the court in Keekstra and in Whatcott does draw, it's a difficult area of law, but does draw some helpful lines between, again, expressing moral views versus, again, basically defaming, right? Whether it's presenting gay men as a threat to children, right? Or presenting a religious group as somehow a threat to society, or, these defamatory generalizations. I think the court is really aiming at those. And I think that's a legitimate concern in law. Again, I raised my concerns with C-9 that I think the existing law that we have does that. I think C-9 maybe needlessly, particularly on the hate propaganda offense, raises some questions about whether the standard is being lowered, and that it shouldn't be.
Thanks. You have emphasized the importance of precision in the law. Do you see the value in Bill C-9's approach using established, court-tested definition to uphold freedom of expression while still giving law enforcement the tool to respond when hate turns into imitation or a threat against marginalized groups or 2S LGBTQI+ Canadians?
If I'm understanding the question correctly, so the legal tools, one of the things that the minister said was that with codifying the definition was to give law enforcement more guidance and make it easier to lay charges. That, and of course, removing the Attorney General's consent. If we have laws, I think we should be able to effectively enforce them. I think the Attorney General's consent, when it comes to hate propaganda offenses, is there because of the unique nature of the offense, right? So when we have a direct incitement to violence or a direct threat, those are, of course, criminal words. There's a direct connection with violence. When it comes to hate speech, there's the connection is less direct, right? And so and there's the potential pitfalls that the court has identified. And so kind of having another layer of review to say, hey, are the essential elements, the more complicated mens rea elements met here? I agree with Mr. Shack that there could be other ways to deal with the problem if these legitimate charges are not being brought, of guidance for attorneys general so that this can be dealt with efficiently and consistently. That may be the way to proceed.
Thanks. So my final question to you is that Bill C-9 also reaffirms that legit debate and discussions are still protected. So do you think that this kind of clarity help bring people together?
I comment on the clarification clause that because it says something is not criminal solely because it humiliates, hurts, or offends, that signals that those are not the only factor, but those may be relevant factors, right? And so in a way that's understandable, how the victim group feels. But strictly speaking, the test that the court has set has said that it's not the views, right? That's the subjectivity concern. It's not the views of the speaker per se. It's not the views or the feelings of the victim group, right? It's the reaction that is intended to be provoked in others towards the victim group. And so I think there are other provisions, other sections of those cases that would work as better clarification provisions that go to, again, not targeting the nature of the expression and that get to that objectivity. I know the Christian Legal Fellowship has suggested some language to reinforce that objectivity. We've highlighted several passages in our written brief in which the court kind of, again, identifies those pitfalls and gives guidance on how to stay objective and how to not interpret the offense too broadly.
Thanks. So my next question is to Mr. Check. First of all, thank you so much for being here and your continued advocacy in fight against anti-Semitism and hate in all its forms. So Jewish Canadians have faced troubling rise in hate incidents. From your perspective, why are strong, clear laws like Bill C-9 so important for protecting Canadians?
Well, I think, as I mentioned, reinforcing the imperative of dealing with the harassment and intimidation that Jewish Canadians have been facing is a very important signal to be sending, and especially in light of the fact that all too often the enforcement hasn't been there. And laws need to be enforced, but they can also be used to send a clear message of what needs to be taking place. And that's what we need more than anything, is a consensus message coming out that these crimes need to be taken seriously. I think having a clear definition of hate will help to clarify the response to it and ensure that hate motivation isn't just something to be considered at the sentencing stage, but is considered as fundamental to the crime itself and will be more likely to be considered at things like bail hearings, where we've seen all too often people released immediately, people who have committed multiple offenses, people who, like the individual I mentioned in my testimony, who was arrested with 3 loaded handguns and a switchblade knife, posing a clear threat to the community.
Thank you. Monsieur Fortin pour 6 minutes.
Merci, monsieur.
Thank you, Mr. Chairman. I wish to thank all the witnesses who are with us today. My first question will be to the representatives of the Quebec Bar. Mr. Nadeau, perhaps you could indicate this C9 proposes to remove the Attorney General's approval to institute charges of hate crimes. In your opinion, is it a good idea to eliminate this authorization, or should it be kept? I will allow Maître Saint-Jacques to answer. Thank you very much. As we mentioned in our brief, at the Quebec Bar, we don't think it's a good idea to withdraw this authorization by the Attorney General because these are offenses that are sensitive, that will lead to public controversy, and we have to maintain some kind of institutional filter to avoid denunciations and so on that lead to charges that are not necessarily well-founded. So the prosecutor looks at the whole situation and has to evaluate public interest. So when he has a complaint, the police receive a complaint and submit it to the prosecutor, he can understand various elements of it. There's the public interest as well as the facts at hand. The fact that there be a preliminary approval by the Attorney General means that private complaints would not be possible. In Quebec, for example, if someone attempts to table a complaint and is not accepted and the Crown prosecutor doesn't accept it, he can always have a complaint filed before a justice of the peace. What this authorization means is that kind of complaint is no longer possible. You can't file a private complaint. It reduces the multiplication of these kinds of complaints before justices of the peace. But a private complaint could be filed insofar as the Attorney General authorizes it. Yes, if a general prosecutor accepts it, that would be the director of crime prosecution. But you have to be careful here. A citizen who goes to a police station to file a complaint will be dealt with by a police officer, then by the prosecutor. If we talk about a private complaint, it's a parallel system where, despite the refusal by the police and the prosecutor to push forward with the complaint, that person could go ahead and present it to a justice of the peace. That will not be possible under the consent of the Attorney General. Thank you, Mr. Saint-Jacques. I'd also like to ask you something that's not in C9. The Criminal Code under Section 319 says that you cannot foment hatred or incite hatred. There are 2 exceptions, however, called the religious exemptions, to the effect that you cannot be found guilty of an offense in the following cases. If you express an opinion based on religious text in good faith, and if you're trying to present this argument for religious reasons, for this religious exception, in your opinion, is this something that could encourage or incite the prosecutor in various provinces to avoid applying charges? Adil Shakawi last fall, about a year ago, saying, Allah, please take care of these Zionists, the enemies of the people of Gaza. Allah, count them all and exterminate them. Spare none of them. So that was said in Arabic, publicly. Many of us think that this should have led to charges for hate propaganda. That wasn't the case. Do you think the religious exception could have played a role in the fact that the prosecutor decided not to pursue charges? I will answer this. Of course, we can't answer your question, as is to say, I'm sorry, I understand your reluctance. I have about a minute left. In your opinion, I do agree that you can't answer for the prosecutor, but from a technical standpoint, would a provision for this kind of defense be something that would prevent such charges from being laid? Well, I think that that exception is not absolute. It is limited by public interest, so that exception cannot be raised. It can be raised, but the prosecutor, in his or her decision to lay charges or not, must take into account public interest, must weigh and balance the rights. We are concerned with these kinds of statements, but also the rights and freedoms of individuals. The Criminal Code states that there is that exception right now, but it must be seen in the light of the public interest as well. So we strike a balance here between these principles, though we will not comment further on specific situations. Thank you, sir. Thank you, Mr. Fortin.
On starting, it will be led off by MP Lawrence, followed by MP Latanzio, Fortin, Brock, and then House Father.
Thank you. And I'll just start out by acknowledging the hatred that Hindus, Jews, and Christians have all experienced over the last years. It's been truly and utterly unacceptable. And never did I think in the Canada that I know and love would ever see a synagogue shot at or churches burned or gurdwaras similarly affected. And I just think it's an absolute shame on our country and something we need to get resolved. I do want to sort of switch to a more technical discussion, and I was very much intrigued by the testimony by the Quebec Bar. You talked specifically about how this bill creates a parallel process that could, in fact, complicate and actually maybe, if I'm putting words in your mouth, but potentially, in my thoughts anyway, impede actually the prosecution of people who commit hate offenses. I was wondering if you'd be kind enough to expand upon that.
I'll allow Mr. Saint-Jacques to answer that. Yes, in fact, this proposal by the Quebec Bar echoes the fact that when you look at the criminal code, you don't create specific offenses for every situation that has aggravating circumstances in the commission of a crime. The circumstances are always taken into consideration by the judge who carries out the sentence. There isn't one for every specific case. Let me give you an example. In determining sentences, the criminal code states that when an offense is committed within a hospital or clinic, or if a minor's involved, these are all aggravating circumstances, but you don't create a specific offense in the criminal code for that. The way this is proposed in the bill, the possibility is created here to add an aggravating circumstance within an offense that has to be committed through another offense in the criminal code. So what is being done right now is that you're creating an offense that has an additional component, and you're giving the ministry the possibility of determining what should be done under the circumstances. Will they go toward something that is more difficult to prove in terms of guilt, or go toward something which is less complex in terms of guilt, but can they use this notion of whether this was led by hate under the circumstances? So what we're submitting here is that this may create a difficulty when it comes to the discretionary choices of the public ministry. I heard one witness say that when it comes to bail hearings, this is not taken into consideration. That kind of offense is not necessarily taken into consideration, but judges who have to hear these bail arguments, they do take them into account, especially if they are committed in these circumstances. All that is in the criminal code.
Back to the Quebec Bar. With respect to the definition, it's my understanding from your testimony that you perhaps find the definition of hatred in Bill C-9 problematic, perhaps constitutionally. Is that a correct understanding?
Maître Saint-Jacques. Oui, effectivement.
Yes, indeed. That is our proposal in our brief. From the standpoint, because when you look at the decisions that have been made by the Supreme Court of Canada, it began in 1990 in the Keekstra decision. There was a definition of hatred as being an intense and extreme emotion, clearly associated with loathing. If you look at the new definition in this bill, it says something that goes beyond disdain and that is denigration or hatred. The reason the Supreme Court said this in this Keekstra decision is because these offenses under the criminal code are reserved for the most prejudicial behavior in our society. You can define hatred in another way. We saw that in the Watcott decision, where hatred is defined a little differently. But when you're talking about criminal cases, it has to be the most reprehensible actions, because this leads to very significant consequences for individual rights. There can be imprisonment when guilt is determined. Thank you, Mr. Saint-Jacques.
Madame Latanzou.
Merci, Monsieur le Président. Merci aux témoins.
Thank you, Mr. Chairman. I thank the witnesses who are here in person or virtually. I'll put my questions to the Quebec Bar, President Nadeau, and the others. The offenses in C9 are restrictive, and there has to be clear intent. So according to each one of you, how does this make it in compliance with the Charter of Rights? Maître Saint-Jacques, would you like to answer? Well, thank you, Mr. President. When you decide whether this is in compliance with the Charter, you have to look at the Oakes decision and others where they minimize the restrictions on the rights and freedoms. More the offense is defined, the more it's restrictive in its wording. And the more you have to ensure that the test of constitutional validity has to be respected. So if I go back to the definition in Bill C-9, feeling stronger than hatred, that is denigration or loathing, don't you think that this is a less strong definition, a weaker definition than what we saw in the Supreme Court decision? I know that there's the notion of a feeling, but how does the definition in C9 compare in your view? Well, indeed, there's the feeling, the degree of emotion. The Supreme Court talked about intense and extreme emotion, but there are different words here. We're talking in the new definition, something that leads to fear and loathing. In the Keekstra decision, they talked about an emotion that is associated with calumny. So the words are different. Denigrating is not the same exactly. Calumny is one type of denigration. When you look at the definition of the Government of Canada, well, calumny can be defined as deliberately libeling somebody to discredit them. Why is it important to go back to the Keekstra decision? Well, because that was a test to verify the constitutional validity under 318 and 319 of the Criminal Code, and they'd looked at whether or not it respected the freedom of speech provisions. By changing the definition and the terms used, you may have to be subjected again to that examination by the courts to determine whether it respects the Charter. What role could the Bar Association help the public better understand the reform once it's adopted? Well, I could answer that. Of course, the Bar assists its members in various ways with guides and training. The Bar also proceeds with various campaigns for the public to sensitize people to the rule of law, various social realities. It goes without saying that in this, as in other matters, we support our members in terms of training and the public in familiarizing them with these notions. How much time do I have left? 50 seconds. The fact of creating a distinct offense shows that hatred is not just one motivation. What is the point of this symbolic or practical infraction by Parliament? Are you talking about creating a specific offense for hatred? I'll let Mr. Saint-Jacques answer that. Well, that's a question that the legislator has to ask. Is it necessary under the circumstances to create a new offense that is distinct, or by introducing in the criminal code, in sentencing guidelines, you could emphasize the fact that this kind of offense is unacceptable in Canadian society, and the fact that it's the circumstances under which they're perpetrated that are unacceptable, you could then thereby increase the sentence. Is that necessary? It's up to the legislator to decide whether it's within the stricture of the criminal code. Mr. Fortin, 2.5 minutes. Thank you, Mr. Chairman. I'll start with Mr. Shack. You heard me read. I won't reread it again. I don't want to make this any weightier, but that quote from Sharkawi from last fall, I'm sure you've heard about it. I'm wondering today, when we examine offenses related to hate, shouldn't we withdraw from the criminal code this exception for religious reasons that it contains now? Isn't that exactly the kind of provision that could influence a prosecutor when deciding whether or not charges should be laid against an individual that says things like Adil Sharkawi did? What do you say about it, Mr. Shack?
It isn't isolated. We've heard similar things being spoken and preached in other parts of the country as well. And I think it speaks to the serious issue that we have, the deficiency with Attorney General consent. The jurisprudence seems to be clear that the religion defense should not be used, cannot be used as a Trojan horse.
Il nous reste environ 30 secondes.
I only have 30 seconds left. Inaudible.
Just say that this is the jurisprudence is clear that the religion defense cannot be used as a Trojan horse to allow otherwise hateful speech to come through, and yet we don't see any prosecutions moving forward with this, and that's something that needs to be addressed. We need to find the right balance to ensure that legitimate religious expression is not coming under attack, but at the same time, religion, the auspices of religious speech are not being abused to advance hateful rhetoric and incite hatred against people here all across the country.
Merci.
Deputy Chair Brock. Vice Chair. Yeah.
Thank you, Chair, and thank you to the witnesses for your participation. Mr. Jain, I don't want you to feel left out, okay? We appreciate your attendance today, so I'm going to ask you some questions. First question I want to put to you, sir. You raised a lot of interesting points in your opening statement. I thank you for that. And I want to talk to you about consultation. Now, the government speaks quite a bit about regularly consulting with all major stakeholders and even minor stakeholders when they introduce legislation. Legislation known as this, the Bill C-9, and given its focus on the swastika, which closely, if not almost mirrors the religious sacred symbols in your faith, I'm wondering if you were consulted at all by the Liberal government. Doesn't surprise me.
There was no
disappointing. Very disappointing. So in addition to what you described in your opening statement in terms of the request for clarification, there really could have been an easy answer to this, simply defining what that the Hawking Cruise and the Nazi swastika, that it does not relate to symbolism in your faith, could have been an easy answer, okay? The government chose not to do that. Is there anything else about this particular bill? Like, there's another aspect to this bill about a symbol that closely resembles a symbol that's described in A and B and likely to be confused with that symbol. How is that going to impact your religion?
Yeah, thank you, Honorable MP, for bringing this point. Yes, I read the point A, B, and C under that section, and point C mentions that anything that resembles in point B, nearly resembles, should be banned. Yes, and that can be addressed. And in my submission, I did mention that in section B, if we remove the word Nazi swastika, we just leave the without Nazi swastika word, it's good enough. Under the defense section, you did include the sentences that if you are using for religious purposes, then they will be protected there. Beside that, in my submission, which will be French translated and you will get it, we are asking for making an explicit exception for the Hindu and Jain community, which was done in the Australia in Victoria State. They made an explicit exception that, and they used word the swastika should be exempted for if it's used for the religious purposes, and there they use that sometimes it's conflated with the Nazi Hawking Cruise. So they are doing a very clear distinction. Also, I have submitted a educational material which has been done by Oregon State in USA by Education Department. It's more of an education matter. If we educate the media, if we educate the law and police personnel, I think this can be very well addressed. People will not be charged for that as long as they know the intent here is the religious purposes and not for inciting hatred against the Jewish community or any community.
Thank you. Turning over to Mr. Shack. You raised also some very interesting points in your opening statement, as well as addressing questions from my colleagues. On the issue of intent, and specifically, I'm trying to find my notes here. Oh, the issue regarding AG consent. You support the removal of the AG consent, but I'm wondering if you have some concerns with respect to the new hate offense that not only applies to the criminal code, but actually applies to any other act of Parliament. Do you see a space in that regard where Attorney General consent would be appropriate?
So I think in terms of the broad application of the new hate offense, I know that there has been discussion about confining that only to criminal offenses or to explicitly enumerated violations of acts of Parliament, and I think that that's a logical and reasonable approach in order to ensure that people aren't being held criminally accountable for crimes where that's not, for violations of the law where that isn't appropriate. With regard to Attorney General consent, there are multiple ways that we can address the deficiency. One of those ways is to ensure that there are clear guidelines and requirements for transparency, what AGs should be looking at and considering, and timelines to ensure that when one of these crimes is committed, it doesn't just go into a black hole and disappear. This would go a long way to ensure that these incidents are addressed.
Thank you, Mr. Chair.
And restore confidence in the justice system.
Thank you. Mr. Housefather for 5 minutes.
Mr. Chair, and thank you to the witnesses for coming forward today. I'm going to reiterate something that I said at previous meetings. Last year, this committee studied anti-Semitism, focusing on anti-Semitism on campus. We put out a report from this committee last December, and the majority of items in this bill were recommendations from the Justice Committee in its report, at which CIJA and other organizations testified. Mr. Schack, I had previously asked this question today to the Edmonton Police Services, and I got a yes answer. Would you agree that this bill does three things? One, it creates new offenses to give more police more tools in the toolbox to tackle, for example, intimidation and obstruction in front of Jewish community buildings and other communities' buildings. Number two, that it clarifies certain elements of the existing law. And number three, even where there are existing offenses, we've had a lot of trouble for them to be prosecuted. This gives a message to police, to the extent the federal government can give a message to police, that it is important for them to prosecute these hate crimes against all identifiable communities in Canada.
This bill puts on the table a new offense to deal with the intimidation and obstruction that we've been experiencing, providing greater impetus for action. And now we're beyond the need for reports. We're at a stage where we need action. And I think that sends a strong message, an important message. No mother should be forced to endure hateful epithets and intimidation, dropping her child off at daycare. Examples of which I've heard myriad times in meetings with local officials in Toronto. We have a serious problem, and we need to be sending the right messages in a unified way to ensure that these issues are being tackled effectively. And it's important that that moves forward.
No, I'm in agreement, but each of those three elements are true. And I think we've heard for a very long time right now, words aren't enough, action is required. Amending the criminal law is the most strong action the government can take, and they're taking these actions straight out of the report related to anti-Semitism from this very committee. Can I ask you the question about the Attorney General consent? I think what your position is that you would, I may be paraphrasing, right? That you think that there may be other ways to address it, but as you know, this committee can't address that in this bill in the ways you just suggested to Mr. Brock. We can't give guidelines, this committee, to how attorney generals should or should not give consent or timelines to provincial attorney generals. We can't amend the bill in that way. What we could do is, if we felt that it was necessary, could remove it from private prosecutions and leave it for public prosecutions. Is that essentially CIJA's preferred position?
Removing
The requirement for Attorney General consent on private prosecutions would go a long way to addressing the most clear area where there could be vexatious prosecution. As your colleague mentioned earlier, there are concerted campaigns across this country to vilify the Jewish community based on who we are and what we believe. And there's already been calls for Jews across the country to be prosecuted for criminal offenses just based on who we are. That's something that we need to guard against, and retaining Attorney General consent for private prosecutions would be essential.
Okay, so I understand that. I would just point out in the Justice Committee report from last December, that was one of the recommendations, and I didn't see anyone actually dissent from that recommendation, but I understand the point. Can I ask you one more thing? We were trying at the end of your 5 minutes to get to the request that we add a provision in the bill for willful promotion of terrorism or willful support for terrorism. Could you talk to that and why it's important?
So the way the bill is constructed right now, it's important to include reference to terror symbols to clarify that those are indeed symbols of hate targeting communities. But I don't know if it meaningfully changes the challenge that the Ontario situation that I mentioned in my remarks brought forward, which was that it was impossible for the Crown, in their estimation, to prove hateful intent on top of the display of those terror symbols. It's our position that the symbols of a listed terrorist entity are inherently hateful. They're inherently symbols of hateful violence, and they should be addressed outright. And the promotion of terrorism that we have seen that's driving radicalization and violence and extremism across this country needs to be addressed. And that can be done in a straightforward way through the inclusion of a willful promotion of terrorism provision that mirrors the other provisions. We've decided as a country,
Mr. Shack, we're at time, so just please sum up.
that promoting genocide and promoting hate are not acceptable. Promoting terrorism is no less evil.
A brief final truncated round in, so we'll do this. We'll have Mr. Bailey for 4 minutes, Ms. Dillon for 4 minutes, et Monsieur Fontaine pour 2 minutes et des miettes. Merci.
Thank you, Chair. Mr. Schock, have a sip of water because I have one more question for you. And we have 4 minutes. So your organization letter proposed developing clear federal directives to guide the Attorney General's consent decision. Now, I believe there was 7. Is that correct? Could you take a few minutes and go through those 7 with us? Because I think these directives should be published in the interest of transparency.
Happy to provide those in writing just to make things faster. But the challenge that we've faced in terms of the status quo is that cases will be brought forward. It's clear that something criminal has taken place, and then they disappear. We don't know if there's a timeline for them to be considered. We don't know what considerations are being undertaken. There's no communication, no transparency. There is no process. And it's very difficult to retain confidence in a justice system where a plausible crime has been committed and there are no answers for how that's going to be addressed. And so we need to fundamentally change that dynamic. We need to make sure that when somebody is allegedly promoting hatred, that there is a clear path forward to have that addressed, to have that considered, and to move that forward. If we can't align on that, then we need to look at alternatives, like removing Attorney General consent, but retaining it for private prosecution to ensure that we don't have an onslaught of vexatious prosecutions that overwhelm the system.
You will provide that list to the committee? Thank you. One other question, please, for Mr. Sickerman. The Attorney General consent requires acts as filters against frivolous, politically motivated complaints. In Bill C-9 as written, what will prevent private complainants from weaponizing and politicizing the provision?
Without any Attorney General oversight and allowing private prosecutions, especially, I don't see a filter.
Mr. Schack, would you like to chime in on that?
As I said, Attorney General consent was put into the law for a reason, and that reason has merit. We're talking about expression crimes, and there should be consideration given to that, and the Supreme Court has considered that in its rulings on the constitutionality of these provisions. The challenge is that it's not working, and things are not moving through the system. And so we have to find a way to ensure that the rights of Canadians to be free from hate and the rights of Canadians to speak freely are both balanced and addressed.
Do I have time? Andrew?
Thank you. Just very briefly, if I could, Mr. Schack. Back in August of this year, 32 Liberal members of Parliament signed an open letter initiated by Mr. Housefather condemning anti-Semitism. 32. That is a small fraction of the governing party's caucus. The same week, every single Conservative member of Parliament signed a letter condemning anti-Semitism, 144 MPs. Do you believe there has been leadership from this Liberal government in condemning and denouncing anti-Semitic hate?
What I'd like to see is leadership from the entire Parliament of Canada coming out of this process to see real action taken and a clear message from the broadest possible consensus driving forward for all Canadians that we stand against the hate that's targeted my community and others, and that that's not part of the Canada that we want to see in the future.
Thank you.
That's what we need to see.
Thank you both. 4 minutes over to what was Ms. Dillon, but passed her time on to it.
Thanks very much. And as Mr. Schack is well aware, and as I made the point to Mr. Lawton when he previously tried to make this implication, my letter that wasn't only my letter, it was Jewish Liberal Caucus's letter, made very specific policy recommendations endorsing all of the recommendations from the Justice Committee report last year, and wasn't a simple condemnation of anti-Semitism. And Mr. Lawton wouldn't have signed that letter because he doesn't support all of the recommendations in the Justice Committee report. So I find it hypocritical at best that Mr. Lawton is raising such a point. Mr. Schack, what I have heard from you today is that, and I do believe that you speak for the vast majority of the Canadian Jewish community, because some people will say, well, Independent Jewish Voices doesn't agree. Would you say that, you know, the groups representing Jews that support the existence of Israel represent over 95% of Canadian Jews?
Well, it's not just me saying so. It's all the available public opinion research data reinforces that the vast majority of Jewish Canadians have a clear and close identification with the people of Israel. There's one Jewish people around the world. The majority of Jewish people in the world live in Israel, and that's a clear bond that we share. And anybody who would suggest otherwise is engaging in tokenism and frankly, outright racism.
What you're saying, though, to us today is you do want this bill to be passed, and you want all of the parties at this committee to work together to find amendments that would secure consensus on the bill, correct?
That's correct. The stakes are high. This is a serious issue that around the world, it's not just conceptual. This is costing people their lives. And we need to treat it with that kind of seriousness that it requires, and to come together and find ways to make this work so that we are speaking with one voice as Canadians, saying that this is not acceptable, we won't tolerate it here, and we're taking action to address it. And that kind of consensus
because
is
anti-Semitism shouldn't be a partisan issue, correct?
Absolutely. Hate of any kind shouldn't be a partisan issue, okay. and we need to all work together on this.
And I think we're in agreement on this side on that 100%, because we need to work together and make sure that we satisfy the concerns that are there in the bill and make sure that this bill passes so we deal with hate against all communities. Mr. Jain, I have one question for you. I had understood, because I have been speaking with groups from the Hindu and Jain communities, that the real concern was the confusion of the swastika, the religious symbol, with the Nazi, image of the swastika, which is why in the bill, when it refers to the swastika, it says Nazi swastika, and then uses the actual German name for that. I understand the requests that you're making, but I do believe the bill was trying to accommodate that by using those words. Would you recommend we look exactly at the language used in Victoria by the Victorian Parliament to create the exception that you're asking for?
That is correct. The word in the so I welcome the usage of the word Nazi Hakenkreuz. Is clearly called out there. You are calling to ban it, which is rightful. You use that word there. Also, the problem there is that in the same line, the wording is Nazi Hakenkreuz, also known as Nazi swastika, and that is a problematic because Nazi Hakenkreuz is different. There is no such thing Nazi swastika. You should not associate the word swastika with Nazi. Swastika is a religious, sacred word. It's a Hindu word. It has nothing to do with German or Nazi party, right? What we are recommending and what Victoria State in Australia did, they clearly made a distinction. Same thing the education department in Oregon, they did that, which I mentioned that. And they have explicit exceptions, which I did in my written submission. So it clearly calls out how you can add those wordings, and that can take care of this problem.
Thank you.
Yeah. And just to add that, and we need to spend some time for money for educating people also.
Thank you, Mr. Jain. Mr.
Thank you.
Father. Et le mot de la fin, ou plutôt les questions de la fin.
The last question will be for Mr. Fortin. Thank you, Mr. Chairman. My question is for the Quebec Bar Association. I don't know which one of you will answer. Right now, hating in Canada is permitted. It's not a good thing, but it's not prohibited to my knowledge. Correct me if I'm wrong. A few years ago, we added the notion of hatred in determining proof, evidence, and C9 wants to make it an element of an offense and saying that a crime motivated by hatred requires a stronger sentence. So my question for you is it still permissible to hate in Canada if we adopt C9? Mr. Saint-Jean? To answer your question, the answer is yes. What we can't do is commit an offense against the criminal code. So that means fomenting hatred or other things that are added in the bill. Once again, I get back to what is hatred. You talk about hatred under the criminal code. It's a definition that's higher in terms of emotion, feelings, and that's what we want to avoid. We want to avoid sharing those emotions and inciting other people to commit crimes because of these emotions that you want to disseminate. It's not that you can prohibit hatred. You can disagree with the way people think for various reasons. What we want to avoid, that ultimately there be offenses committed, that is violence, because of behavior. No, I'm sorry, that's it. That was just 2 minutes, sorry. Thank you. Thank you, everyone. I'd like to take the time to thank the witnesses.
At time, I would just briefly remind people before we adjourn that there will be no meeting on November 4th. That's Budget Day. As long as we keep all our senses, we'll see you then next Thursday. Thank you.